examine tomorrow.
Obliged.
Final order? Is it final order, coordinate bench?
Yes, Your Lordship. It is single judge order, Your Lordship.
All right, it's a final order. Give a copy to him. Let him have an opportunity of examine that.
I have given you.
Serial number 2,
Obliged.
Mrs. Sangam Medisur Private Limited versus the State of Bihar for the petitioner Sri Govind Agarwal.
May please, Your Lordship.
Tender is only for 1 year. Yes. Continue on. Depend. Draw, as long as it is not done. Yes, sir.
May please, Your Lordship. Your Lords, with regard to a decision of the state government to set up common biomedical waste processing plant. Now, my Lords, Annexure 1, my Lord, I'll just, because it is in Hindi, I'll just tell Your Lordships that a meeting was held on 6 July 17 by the state government, wherein it was decided that they have to establish the common effluent treatment plant
July 2017.
17, Your Lordships. First meeting was held, that is Annexure 1 at page 34. 6 July 17 at page 34, my Lords.
6 July 2017.
Your Lordships.
Yeah, first
First,
inviting tender.
no. It was the first meeting of the state government was held, wherein it was decided that the biomedical waste treatment plant has to be set up in the state at Madhepura, Bhojpur, and different places, my Lord. Now, my Lord, thereafter, this decision was reiterated by the Annexure 2 in another meeting held on 11th May 2018, which is at page 37, my Lords. Now, pursuant to these decisions, a tender was invited, that is Annexure 3 at page 40, inviting participation of bidders for setting up biomedical waste treatment facility, my Lords.
What is the date of NIT?
NIT is, my Lord, the time of downloading the tender was 18th October 2019 to 14th November 2019.
What is the last date?
The last date was 15th November 2019. Now, my Lord, this was invited, in which, my Lord, we submitted our tender. The technical bid was held. We qualified in the technical bid, and then, my Lord, we were invited to participate in the financial bid. And for this purpose, we were required to deposit our EMD, my Lord, 5 lakhs each, which was done by us. That is Annexure 5 series, page 46-47. Now, my Lords, pursuant to our selection in the technical bid, we were all invited for financial bid. That is, my Lord, Annexure 9 at page 52. Now, my Lord, if your Lordship will kindly turn to page 52, wherein this is clear, my Lord, dated 1/9/2020, my Lord. Kindly come to page 52. Now, my Lord, if your Lordship will see this financial committee meeting for tender number so and so, With reference to subject mentioned above, this is to inform that tender for establishing and operating common biomedical waste treatment facility at Jan Nayak Karpuri Thakur Medical College and Hospital, Madhepura district in the state of Bihar under public-private partnership mode was floated via the tender number so and so by Bihar Medical Services and Infrastructure Corporation Limited, Patna. It is to bring to your notice that Financial Committee meeting is scheduled on 2nd September at 4 p.m. for opening and evaluation of price bid of technically qualified bidders in Conference Hall of BMSICL, 4th floor, Bihar State Building. Therefore, you are requested to make it convenient to attend. And in the bottom, your lordship will find at serial number 3, those who were technically qualified. 4th number, Synergy Waste Management and Sangam Medicine. We are Sangam, my lords. So, we were invited. Then, my lords, thereafter, on the website of BMICL, it was uploaded that so far this place is concerned, I have become L1 for Madhepura, my lords. But they did not, apart from my lord uploading at the website, they did not communicate me through an LAO because, my lord, the land was not available in Madhepura, my lord.
Where is the allotment? You are the successful bidder.
Yes, my lords. I am the.
This is page 52 is inviting for financial bid.
Your lordship.
What
Thereafter, they uploaded it on their website, my lord. That I have become L1, my lord.
Where is that?
Unfortunately, that copy we don't have. Lord, we was waiting that they will give.
Conclusion that you are the successful bidder.
Lord, my lord, we have stated so because, my lord, after selection of land, we were asked to make verification of the land also, my lord. My lord, in fact,
That communication.
dear lord, my lord, that communication is.
No, they don't issue any material that you are the successful bidder.
They have not yet issued because they said that land is not available. As soon as the land is made available, we will do it. But they did not do it.
Correct, sir. That means it has not attained finality.
But so far as the tender is concerned, everything which was required to be done except
Everything will be completed once the work order is issued and thereafter agreement and other things.
Correct,
Huh.
they did not do it, nor they cancelled the tender for any reason. Now they have come out with the fresh tender. So we are aggrieved by that you have to communicate us. Your lordships. Fresh tender is annexure 17 at page 75 minutes.
You also participated?
In this tender.
Huh.
Yes, my lord, we have submitted our tender. Because, my lord, we could not have taken that risk that, but we challenge this. My lord, if your lordship will come to page 94, yes, just a minute, I'm sorry.
This, fresh tender is in respect of same.
Yes,
Uh,
yes, my lord, that is at page 95, your lordship will see that is also part of this.
no, they have identified the number of district.
Yes, earlier also they have done it, my lord, in the
Where is
same.
that earlier? You are not producing NIT of earlier?
Yes, yes, that is annexure 4, my lord, kindly see. Page 43, my lord.
Where is the identification of district?
Your lordships, my lord, if kindly come to page 44, my lord. This is para 3 of this NIT, my lord. If your lordship will have pleasure to see, district Patna, Bhojpur, Nalanda, Buxar, Rohtas, Kaimur. This is one. I'm sorry. Kindly come. There were 2 tenders, my lord. Kindly come to page 47. Page 47 nahi hai. Just a minute.
47.
Yeah, but sorry, page 41, my lord. Page 41, I'm sorry. It starts from page 40 at page 41, para 3, my lords. In the districts of Madhepura, Supol, Purnia, Katihar, Kishanganj, and Araria. So earlier also for the same district, and my lord, in one of the meetings, if your lordship will have pleasure to see that at page 57, they have also mentioned in the meeting, my lord, if
No, the new NIT is Patna 2, Gopalganj 1.
okay, my lord, page kindly come to page 94, my lord. This is the part of the new NIT, my lords. And in this NIT, your lordship, it is there, my lord. Based on records of number of beds, requirement of 9 CBWDF has been assessed. And at page 95, your lordship will find serial number 7. Serial number 7, which matches with page 41, my lord. Page 95. And
Who is appearing for Bihar State Pollution Control Board?
Yes, my lord, I am appearing.
What is the reason for not completing the process of?
Earlier it was, my lord, as per 2016 rules, my lord, and regulations. Bihar State Pollution Board is the authority, appropriate authority under rules and Central Pollution Control Board's guidelines, my lord. That is statutory in nature. That is not on record, my lord. If required, I will produce it in my counter affidavit, my lord. They have to do it, my lord. Now, another aspect is under the...
Have you informed this Bihar Medical Services and Infrastructure Corporation Limited that you have no authority
in fact,
for NIT?
My lord, my instructions on...
No,
My
it
instruction-
should not be overlapping.
My instruction on telephone is that, my lord, this the earlier which was issued by BMS IACL, my lord, that will not be finalized, and this will be the final.
That will be. What is the reason for not finalizing?
Because there was no gap assessment. What they say that, my lord,
There was no.
one aspect is that there has to be a gap assessment. Gap assessment meaning thereby that out of the existing coverage area of any facility, my lord, it has to be seen how much beds they are catering and what is the area they are catering to.
No, both this pollution control and this corporation limited will come under which department?
Pollution
Commerce
control,
and- commerce-
independent body under the forest department, my lord, administrative control.
Well-
Forest and environment and forest department, but my lord, it is an
The pollution control board will not come under the industry and commerce.
it is my lord
Then
independent.
how can you say forest?
No, I'm sorry, my lord.
What about the corporation, this BR Medical Services and Infrastructure Corporation Limited? That will also fall under the industry.
Yes, ma'am.
Have you implemented the industry and commerce?
sorry, my lord.
Principal Secretary, Industry and Commerce.
Industry.
Have you implemented?
No, my lord, if in the decision of the state government, it is, my lord,
Sir, you have to implement the principal secretary,
we have in
industry department, because we have to ascertain who is empowered to.
lordships. In para 3 of our writ petition, my lords,
No,
We
you
have-
have not implemented the industry
Bihar,
party.
my lord, this is in para 3, my lord, the state government, high level committee of the state government, my lord, they have made this Bihar State Medical Services Infrastructure Corporation as the nodal agency for this purpose, my lord. That is, if your lordship will see, that is clear from page 34, my lord, annexure 1. Page 35, it is clearly mentioned there. I will translate it, my lord, it is in Hindi, paragraph 11 at page 35. My lord, it says, अस्पतालों में बहिष्राव,
Who is the author of this document?
this document is Principal Secretary Health, who is also the chairman of state level advisory committee for.
There is no control over pollution control. Now the issue is power is vested with the Bihar Corporation or the Pollution Control Board.
Biomedical waste is concerned, my lord, section 11 says that it has to be done by an advisory committee, my lord. Section 11 of
Section,
biomedical waste management rules 2011, my lord. 16. It is,
there are those.
my lord, we have quoted it, my lord. Kindly come to paragraph 4 of our petition.
I have a marked copy, my lord, will permit.
Huh?
I have a marked copy of rules, my lord.
What mark copy?
But because Rule 9 is the prescribed authority, my lord. It says the Bihar State Pollution Control Board will be.
If Lordship will kindly see paragraph 4 of the writ petition also.
Page 4,
Page 7, my lords, para 4.
7.
That's page.
You don't,
No, my lord, we have quoted the rules, my lord. Extract of the rules, my lord.
but what is the title of the rules?
Rules is, my lord, Rule 11 Advisory Committee. Biomedical Waste Management Rules, Rule 11, my lord. It says that every state government or union territory administration shall constitute an advisory committee for the respective state or union territory under the chairmanship of the respective health secretary to oversee the implementation of the rules in the respective state and to advise any improvement, and the advisory committee shall include representatives from the Department of Health, Environment, Urban Development, Animal Husbandry and Veterinary Sciences of that state or union territory, State Pollution Control Board or Pollution Control Committee, urban local bodies or municipal corporation representatives from Indian Medical Association, Common Biomedical Waste Treatment Facility and non-governmental organization. And this committee was regularly meeting, my lords.
Where is the rules?
It is Rule 11, my lords. 2016 rules, my lord. Environment Pollution Act.
So who has been empowered, whether pollution control or this corporation?
My lord, in the meeting, it is the corporation. If your lordship will see,
Not meeting, sir.
in that
Rule 9 says that prescribed authority. What is this?
that is for the purpose of
Where is this? Under the rules, where is the establishment of this biomedical waste unit is required to be established? Establishment of common biomedical
waste treatment facility, your lord.
under rules, which is the relevant rule?
17 will be relevant.
17.
17.
The rule 17 is relating to site for common biomedical waste.
And Rule 5, my lord.
Rule 5.
Rule 5 also. Duties of operator of a common biomedical waste treatment.
That is a different thing completely. Duty. Once it is at place,
No, sir, where is the establishment of this common biomedical waste treatment?
Well, it is under the guidelines issued by the Central Pollution Control Board in exercise of power under Rule 17, Clause 2.
Huh?
It is under the guidelines issued by the Central Pollution Control Board, my lord, in exercise of power under Rule 17, Clause 2. That copy.
उसको करा है कि कौन बट करेगा कौन my lord, may I invite my lord? My lord, so far as the power of monitoring is concerned,
Monitoring, we are not establishment.
no, my lord, establishment, my lord, everything is to be done by the advisory committee. In the Rule 11 itself, your lordship will find this. If kindly come to again rule.
Which is that establishment of
My lord, in advisory committee is here, where, my lord, it will be mentioned common medical, biomedical, last line, my lord, in sub rule 1, representative from Indian Medical Association, common biomedical waste treatment facility and governmental organization. And your lordship will see, my lord,
no, this is constitution of advisory committee. Where is the establishment of this? Who has to establish?
My lord, under the guidelines, my lord, may I pass on?
my lord,
The only criteria. Who has to establish, sir?
There, State Pollution Control Board.
Without-
He has
Where is that? You are saying orally.
Rule 2, my lord, that is in the paragraph 2, which I have passed, my lord. I will
Of what?
paragraph 2 of the guidelines, which I have just the second document, my lord.
No, this is only criteria for development of new criteria. But who is the competent authority?
My lord, it is State Pollution Control Board only, my lord.
All oral submission.
No.
Prior to allowing any new CBWTF, following criteria steps may be followed. Prescribed authority under the BMW 2016, that is the State Pollution Control Board, in the respective state or pollution control committee in the respective union territory is required to prepare an inventory or review.
Power is vested with.
नहीं भाई ये है facilities.
This is the paragraph.
Milord, instead of Milord, I don't want to waste your lordship's time.
We will ask the chief secretary to file affidavit. Please take down.
May I place that rule? Guidelines which I have passed, my lord.
Sir, please show us that. Who has to establish this common biomedical waste?
State Pollution Control Board, my lord, that is
Where
unsubmitted.
is the power given to them?
Page number 2 of the rules, my lord, which I have passed. Prior to allowing any CBWTF, following criteria or steps may be followed. Prescribed authority under the BMWM Rules 2016, that is State Pollution Control Board in the respective state or pollution control committee in the respective union territory administration, is required to prepare an inventory or review with regard to the biomedical waste generation at least once in 5 years in the coverage area of existing biomedical waste treatment disposal. The prescribed authority is also required to extrapolate the coverage area of biomedical waste generation for the next 10 years. SPCB/PCB is required to conduct gap analysis with respect to coverage area of the biomedical waste generation also projected over a period of next 10 years, adequacy of existing treatment capacity of the CBWTF in each coverage area of the radius 75 km as given in Annexure 1C. Then all the SPCBs and PCCs shall conduct the gap analysis, and based on the gap analysis, action plan for development of new CBWTF is required to be prepared and submitted to MOEF and CC and CPCB within 6 months' time. In case of state/UTs where no CBWTF is available, in such a case, SPCB, PCC being prescribed authority under the rules is required to submit the detailed proposal to.
Let them file affidavit. Yes, take down. Matter relates to tender process respect biomedical waste treatment facility. Various districts, places of state of Bihar. Bihar Medical Services and Infrastructure Corporation Limited have processed notice inviting tender on 18/10/2019. And it has reached the stage of opening of financial bid. So for want of land, process of NIT issued by the corporation could not be finalized. So when things stood thus, State Pollution Control Board proceeded to issue notice inviting e-tender on 22/12/2022. So, the petitioner is a successful bidder as claimed by him with reference to NIT issued by the corporation. So therefore, there is a overlapping as to who is the competent authority, whether Bihar Medical Services and Infrastructure Corporation Limited or State Pollution Control Board is the subject matter So in this regard, the Chief Secretary, Government of Bihar, Patna is hereby directed to file affidavit with the relevant rules and appoint who is the competent authority to proceed with the NIT in respect of the establishment of common biomedical waste treatment facility in various districts of the state of Bihar. Before the next date of hearing this matter after 2 weeks.
My lord, there is another matter filed by the same person regarding Patna. My lord. That means notice has been issued and then it has been transferred to your lordship's bench, my lord. That may also
Give the number. This matter along with so and so.
376 of 2023, my lord. May I take the copies, my lord?
But meanwhile, they should not finalize the tender. Today is the date, my lord.
Sorry, sir.
Only thing
You have also participated, no?
that's there, my lord.
Yes.
My lord, like, my lord, if your lordship is just
Sir, if they don't have power, it will be set aside.
lordships, only, my lord, kindly see this order, my lord, of this, a division bench of this honorable court, my lord. They have said that you can proceed
If you
with.
want the interim order to be rejected, we will reject.
Not that, my lord. I am saying that only they may finalize with the leave of the court, my lord.
Sorry, yes.
Otherwise, they may make it infructuous, my lord. That is,
Sir, we will see that it will.
my lord, your lordship may not pass the order. Only your lordship will just see this.
Serial number 3, Rashtriya Lok Vikas Sangh versus
Oblige,
State
Lord.
of Bihar Petitioner Sri Niranjan Chatterjee.
My lord, in this case, I appeal for the state, my lord, and after receiving rejoinder from the counsel of the petitioner on 23/2, my lord, instruction has been sought for filing supplementary counter affidavit in the instant case, my lord, and the matter was directed to be listed on 16/3/2023.
Then why it has been listed today?
I mentioned, Lordship had directed us to mention if the counters have been filed. And that's why this has come, Lordship. One mentioning this has come.
And counsel for the respondent intends to file supplementary counter affidavit in the light of rejoinder filed on behalf of the petitioner after 2 weeks.
Lordship, by that time, Lordship, tender might have been, tender will be finalized by the authorities, Lordship.
Sir, what is the date of financial bid?
4th को होने वाला है।
4th March. 14.
14th, Lordship.
14, we have time, no?
And 4th को last date of submission है.
So 4th February is the last date of submission of tender.
Nothing.
And 14th March is the date of finalization, Lordship.
So on 13th.
My lord, personal affidavit on behalf of respondent number 2 and 3 has already been filed, my lord, and in which sufficient reason has been assigned, my lord. That as to why the
What has been assigned?
my lord, a new scenario has been developed in the state, my lord.
What is that new scenario?
Bihar cabinet in its decision.
Lordship will kindly hear us, Lordship, for the time being ignoring that our rejoinder which is
You reserve all those arguments on 13th.
My lord, my
Why
lord.
you want to mention?
My lord,
It's already adjourned.
My lord, I am sorry.
The heading for orders to petition serial number 4, the State of Bihar others versus Srimati Ragini Kumari others for the Sri Pushkar Pandey.
Lord, earlier there used to be batch of cases, my lord, and from there it has been dealing. And in that case, your lordship, this order has been passed by your lordship. Palavar. Your Lordship will see the impugned judgment, which is dated 26th of November 2012. My Lord, the stand of the state was, my Lord, in the counter affidavit that the university has regularized the services of this petitioner, writ petitioner, without a sanction post. That was the main objection, Your Lordship, and the other.
What is the date of regularization?
Nine 7/2009 by the inverted 9. By the,
Now you are reopening.
this is under challenge, Your Lordship. This impugned judgment was under challenge. My Lord, in short, Your Lordship, pursuant to the order passed by the committee, I will not waste, Your Lordship, because of that judgment, my Lord, I have limited argument to make.
Then in terms of that, we will dispose. But
Only one.
on the other day, he said that matter is relating to only monetary benefit.
The exercise that your lordship had directed the state government to do, that exercise already been done by the...
Correct. Where is your prayer in the writ petition?
My lords. Writ petition, your lordship, kindly see. 12814, your lordship. My lords, writ petition is filed for the prayer to pay salary of the petitioners 9/7/2009 with interest admissible upon the said amount as the current salary, your lordship. Now this is, in that writ petition, your lordship, I have annexed one order, one judgment, your lordship, passed in batch of cases, annexure 1, your lordship. Now pursuant to this judgment, your lordship,
One second. His grievance is only in respect of payment of salary. There is no question of interference with this regularization. Whether he respondent is entitled to salary for that particular period or not.
Because not persons who have been regularized by the university. Lord, in the previous litigation, Lord, there are other persons also. Persons who were appointed in a sanction post 6.
Please forget about that. Whether rightly or wrongly, regularization order is already there. You are not withdrawn, cancelled, modified. Therefore, whatever the benefit flowing from such regularization, the respondent is entitled. Pay the
Kindly come to me.
salary.
That referring to that judgment,
Different aspect.
what I want to communicate is that is, my Lord, internal page 13 of the judgment, impugned
We
judgment.
will not look into that file at all.
Your Lordship would like to look into. Thus, the state authorities are directed to release necessary fund for payment of salary to the petitioner from the state from the date of the regularization within 1 month from the date of receipt, production, communication of this order, considering them to be on deemed sanction post. However, in the peculiar facts and mercy of this case, I am not giving any direction for grant of interest on the unpaid amount. The university would pay the arrears and current salaries to petitioners who are not already being paid their salary within 4 weeks from the date of receiving of such fund released by the state. However, in case the amount is not paid within the aforesaid time frame, then the petitioners would be entitled for simple interest at the rate of 12% per annum to be calculated from the date of amount become due to the date of his final payment.
This regularization of the respondents
Sir,
have been done, your lordship, pursuant to the 3-man committee constituted under the directions of...
Sir, bench is with you. Why you want to argue?
In that case, my Lord, although that was also regularization, my Lord, no.
Sir, that prayer in that petition is different from this. In this petition, limited is whether petitioner is entitled to arrears of salary from 9/7/2009 onwards or not.
If your Lordship would be kind enough to look into this, my Lord, interest part, because of the stay order passed by the division bench, my Lord, when the LPA was filed, there is operation of a stay in this case of the impugned judgment. Perhaps your Lordship.
Please present LPA. There was an interim order.
Yes, your Lordship. And that's why your Lordship would like to, my Lord.
What is the date of interim order in the LPA?
Yes, orders. Orders is बढ़ा दीजिए, हम जो दिए थे.
7/7/2016.
Huh?
7/7/2016, your lordship.
7/7/2016.
My lord.
Interim order was there.
My lords.
Interim order was there.
In the meantime, operation of the impugned order dated 26th November 2012, passed by the learned single judge in CWC 12814 Salomon State. provided the university continues to pay daily wages to the institutions they are working with. This is the writer.
Interest at the rate of 8% per annum.
My lord, perhaps would like to consider that since there was judicial order of a stay, and that's why this part, my lord, this period.
No, you should have deposited in bank, subject to result of LPA.
Lord, if there is order of a stay, my lord, regarding implementation of the order, where the question that I'm putting that
Why the litigant should suffer?
if they can derive benefits of the judicial order, my lord, they have to suffer also.
No, sir. They are entitled to interest.
My lord, in view of the stay, judicial order of a stay by this division bench, by the division bench, your lord, say.
What is the order of the learned single judge?
Internal page 13, last page of that impugned judgment, last paragraph. Thus, the state authority, internal page 13 of the order.
Modify only 12, interest of 12% to that of 8%.
But, my lord, during the period of a stay, my lord,
Yes.
when the period of a
During period of first stay, respondent is entitled.
that perhaps may I make this submission, my lord, and if allowed to make this submission, my lord, with liberty. My lord, since there was.
Better concentrate on some other case. It's taken.
May I leave, my lord?
Yes. Recent LPA. State has aside the order of the learned single dated 26/11/2012. So, respondent dash petitioner in CWJC so and so has prayed for the following relief. The question for consideration is whether the respondent is entitled to salary attached to the post held by her with reference to date of regularization or not. Next, learned counsel for the appellant submitted that initial appointment of the respondent is not against a sanctioned post. Therefore, she is not entitled to salary and so also regularization. The effect from 9/7/2009. Perusal of the records. Next, perusal of the records, it is evident that a regularization order of the respondent has not been withdrawn, modified, cancelled even to this day. Therefore, question for consideration is very limited to the extent whether the respondent is entitled to arrears of salary, salary attached to the post with effect from 9/7/2009 or not. To stop. Undisputed facts are that her services were regularized when she was working on ad hoc basis. To stop. Having regard to the fact that her services were regularized, she is entitled to pay scale attached to the post against a regularized post. Next, we find that there is no error committed by the learned single judge so as to interfere with the order dated 26/11/2012 passed in CWGC 12814 of 2010 on merits. However, we are interfering insofar as the award of interest on arrears that a respondent is not entitled to 12% interest on arrears of amount, for the reasons that Reserve Bank policy in respect of payment of interest in a circumstances of depositing fixed or any other circumstances, interest cannot be beyond 8% at the relevant point of time. Therefore, award of interest at 12% is modified to that of 8%. To the concerned respondent is hereby directed to settle arrears of concerned respondent is hereby directed to calculate difference of salary the respondent from 2000 9/7/2009 and disburse same along with interest at the rate of 8% per annum within a period of 3 months from the date of receipt of this order, failing which the petitioner is respondent is entitled to litigation cost and it is quantified at rupees 50,000.
Serial number 5, Ruchi Kumari versus the State of Bihar for the defendant Sri Chandrasekhar Singh.
May please, Your Lordship. My Lord, the IE application has been listed for conference.
My Lord, I am appealing for the same, and we are seeking time to get instruction from the department. In last occasion, as per the order of this court, we have
2018 matter, sir.
Yes, my Lord, we have received the copy of the brief few days back, my Lord, and we have issued a letter to
Brief you received?
Yes, my Lord.
2018 matter. Where was the brief?
My Lord, we kindly see last order, my Lord, 24/1/2020. The file was already.
Earlier, it was conducted by the different law officer, my Lord.
The state on matters of the year 2018 in order to give an opportunity to the respondent for filing a counter affidavit if any, release this matter after 3 weeks. It is made clear that no further time will be granted.
Your Lordship, in this case, private respondent is there, Lordship. On his instance, the case has been...
Third, private respondent.
Notice has not been issued, my Lord.
Why give the fine?
Notice may kindly be on number 11.
Notice has not been issued, my Lord.
What is the claim? What is the claim of the...
Lord, he has come before this, the petitioner had come before this honorable court against the order of the district appellate authority, my Lord. The district appellate authority has passed the order.
For what post?
Panchayat teacher, my Lord. He was initially appointed as Panchayat Shiksha Mitra, my Lord. Thereafter, my Lord, the post was abolished. And, my Lord, he was...
No, Subodh Sharma was appointed as a Panchayat teacher.
He is also a Panchayat teacher, my Lord. He has already been
He
appointed.
also means you are also appointed.
I have also been appointed.
Then why there is a dispute between two appointees?
Lord, he created dispute, my Lord. I am serving, but in spite of appointment, he created dispute, my Lord.
No, both of you are appointed together.
Appointed elsewhere, my Lord. He has not appointed where I was appointed, my Lord. He appointed elsewhere, my Lord.
To notice to the private respondent Subodh Sharma, the necessary requisite shall be paid within a period of 2 weeks. Main matter be listed after 4 weeks.
तो इसका टाइम थोड़ा सा नोटिस का बढ़ा दीजिए. अगले वीक में पूरा बंद है हुजूर अब.
Correct, sir. 2 weeks is not sufficient.
Case number 6, Ashwani Kumar and others versus the state of Bihar and others for the appellant Sri Vinod Kumar Sinha.
May please your lordships. Lords, this appeal is against the order. The facts of the case are that after 26 years of continuous service, and that too having been confirmed in service, and having been also given ECPs from time to time, all these 3 repetitive lords were dismissed from service without holding any departmental inquiry as envisaged under the CC Rules 2005. No charge memo, no list of documents, no list of witnesses.
Where is the order of appointment?
Lords, they were earlier appointed as daily wage workers. So in 1989, if my lord would kindly come to annexure in the writ brief, annexures 4 and 5. Page 43.
Initially, daily wager.
My lord,
Thereafter?
more than 1 year, and then they were absorbed, they were taken in 1989. And since
No, their appointment itself is 89.
Yes, 89.
Regularization?
No, their initial appointment was, my lords, from September 1988 to October 1989, and then one on 28th October, the second on 30th of November 1989, they were appointed. And since then, they have been continuing. Not only that, my lords.
All right, sir. What is the date of regularization?
From that day, my lords, 28/10/89 and 30/11/89. That is the date of regularization, my lords.
Where is the order?
My lords, for that your lordships will kindly come to my lords. Firstly, Annexure 2, that was the initial one.
Annexure 2.
Series, that will be page 29 and 31. And then, my lords, further annexures 4 and 5 at page 43. This annexure 2 at page 29 is 28/10/89. This contains the names at the bottom. Your lordships will see Ashwani Kumar, that is petitioner number 1, and number 3 Ranjan Kumar is the petitioner number 2.
No, page 29 is in respect of 2 persons?
2 persons. And then page 31, your lordship will kindly see, my lord.
30?
Page 31. This is with reference to Randhir Rai, the petitioner number 3. This is dated 30th of November. At page 32, the date your lordships will find. 89.
89.
Lordships. And since they have been working, and Annexure 3 is a document which my lords would kindly come to my lords. This contains all the service details at page 33, serial number 5, the petitioner number 1, Ashwani Kumar, his date of birth, date of superannuation, Niyukti Tithi, the date of appointment 1/11/1989, and Seva Sampushtiki, the date of confirmation 1/11/91. And then my lord will kindly turn the page to page 34. At serial number 10, the third item, Randhir Rai, he is petitioner number 3. At column number 2, your lordships will kindly see date of appointment 1/12/89 and date of confirmation is 21/2/1992. Lordships. Kindly turn the page, my lords, to page 35, next page. At serial 38, the petitioner number 2, Ranjan Kumar, page 35, next page. Serial number 38, the petitioner number 2, the date of appointment in the second column 1/11/89 and last the column, the date of confirmation, 1/2/1992. And further, your lordships will kindly see in this series, my lords, at page 37, the ACP and details are contained.
ACP.
My lords. This is with regard to ACPs to various persons. And your lordships will kindly, in this page 37, your lordships will kindly turn to page 38 at item 293. From the bottom, the fourth name, Ashwani Kumar, that is petitioner number 1. Kindly see the full details again, and column number 2, 1/11/89, date of appointment. The second column, Prapt, means the first ACP had been given, that is mentioned. Then in the third column, the second ACP on 1/11/2009, and grade pay 4600 is also mentioned there, my lords. Then as regards the third, since the date had not come, it is not mentioned. Then, my lords, turning the page 39, the second name, Randhir Rai, he is petitioner number 3. The second column, 1/12/89, date of appointment, at the top, second. Then ACP, first one, Prapt, means given. The second one, 1/12/2009, and the grade pay 4600 is also mentioned. Likewise, my lords, next page, at page 40, the petitioner number 2, second name, Ranjan Kumar. Three petitioners. Lords.
SC number 326.
Lordships. So, my lords, submission is, my lords, that all these petitioners, they have been always treated by the respondent, my lords, to be in regular service, having been paid. All of a sudden, my lords, they are issued this letter, annexure impugn order, my lords, that is annexure 12.
29/1/2016.
My lords, that is 29/1 exactly. Annexure 13, at page 113.
What is the date?
My lords, date is 29/1/2016.
Correct, that's what we are saying.
My lords.
Termination?
Termination, my lords.
What is the learned single judge?
My lords, learned single judge says, my lords, that since there is already a full bench decision saying that in the initial years, the special officer had no power for making such appointments, and therefore these appointments having been found to be totally illegal, therefore there is the very appointment.
Who had appointed then?
The special officer of that is equivalent to the joint director in the Animal Husbandry Department.
So designation is only special officer?
Oh, my lords. It was a special creation, that is intensive cattle development program was there, in which certain posts had been created. The post which the petitioners were holding, that was progress assistants in these 3 departments.
Yes.
The main ground of attack is that, my lords, that after 26 years, and 2 of them, my lords, petitioner number 2 and 3, I may point out, they have during the period already reached the age of superannuation, my lords. The petitioner number 2 in February 2022, and petitioner number 3 in January 2021. All these details are in Annexure 3 series, which my lords have. And this petitioner number 1 is going to superannuate this year, my lords. This being the position, my lords. And there is no denial in the counter affidavit. It is there that there has been no departmental inquiry, no issuance of charge memo. And if your lordships would permit me, lords, I am tempted to give a list of that, lords, recent decision of this honorable court only, which contains, it is for this purpose that I am giving, the Supreme Court decisions, my lords, which have been relied upon, saying that in view of the fact Karunakarans and other decisions are mentioned.
This is a departmental inquiry.
Well, departmental. I am talking of departmental inquiry only.
No, there is no departmental inquiry.
No. I am only on that. There has been no departmental inquiry.
No, why departmental inquiry is required?
because they are government servants, confirmed government servants, holding government posts, and the CCA rules 2005 is meant only for that, my lord, sir.
Not at this stage.
Lord, sir, this stage means they were at the fag end of.
No, we'll give relief otherwise.
My lord, sir, that is another matter, my lord, sir.
Yes, sir. Please for respondent.
My lord, in this case, I have already filed, my lord, the counter affidavit. What had happened, my lord, in this case, several persons were illegally appointed. And when my lord came to the knowledge of the state, they were removed. Certain persons were, my lord, transferred to the Jharkhand High Court, they were also removed. They moved before this honorable court in a writ petition. That was, my lord, went to, my lord, transferred to the full bench. And full bench decided that this type of appointment by unauthorized persons without following the procedure under the law, without advertisement, etc., and found that their appointment was illegal. And that full bench was, my lord, challenged before the Honorable Apex Court, and Apex Court affirmed the, my lord, the full bench. And on that account, my lord, this case also, my lord, come within that category. It is why, my lord, the Honorable Single Bench said that the full bench is binding upon me, therefore no relief can be granted.
Sir?
My lord.
In the full bench decision, the order opening of regulation after a decision, that is in respect of regularization, not in respect of reopening. Here in the case is reopening. Huh? Yes. Whether have they said that reopening could be undertaken? Umadevi judgment.
Considered that Umadevi cases.
Whether regularization can be reopened. On the other hand, if I am correct, in Umadevi decision, the already regularization orders cannot be reopened.
It is termination, not the reopening of my regularization.
Yes, regularization followed by termination.
Because, my lord, on similar transactions, my lord, other persons who have been removed, they have moved before the Apex Court.
But such a contention is not taken. How is it permissible? We will hold that judgment is full bench decision is judgment in per curiam.
That your lordship. That your lordship can. Lord, impugn order, my lord, the judgment of the Honorable Apex Court in the matter of Umadevi Supra.
Show us the relevant portion of the full bench decision that the authorities can reopen the regularization and proceed to rectify it.
That is, I think, my lord, in Umadevi there is no such.
Yes, take down. Instant LPA is filed against the order of the learned single judge dated 31/7/2018, passed in CWJC 42/24 of 2017. So, brief facts of the case are that three appellants were initially appointed in the year 1988-89. Their services were regularized on 6/11/1991, 21/2/1992, and 21/1992 respectively, as is evident from the documents. Further, it is noticed that they have been extended with effect from 1/11/2009, 1/12/2009 and 1/11/2009 respectively. In this backdrop, concerned respondent proceeded to terminate the services of the appellants on 29/1/2016 on the sole ground that their initial appointment were made by a special officer who is not the competent authority to appoint them. Such action has been taken with reference to full bench decision of this court dated 25/11/2014, passed in
Your Lordship.
passed in Shashi Bhushan Kumar. CWJC number 1290 of 1996. Feeling agreed and dissatisfied with the order of the termination dated 29/1/2016, CWJC 4224 of 2017 was filed. So, one single judge has rejected the petition while affirming the order of termination dated 29/1/2016. Hence, the and counsel for the appellant vehemently contended that the appellants were appointed on ad hoc basis the year 88-89. Thereafter, their services were regularized in the year 91-1992, and they have been extended benefit of ACP the year 2009. In this backdrop, abruptly terminating their services without resorting to departmental inquiry departmental inquiry was warranted in order to ascertain whether their initial appointment was ordered by incompetent authority, and thereafter the appellants have rendered service from 88-89 till 29/1/2016. At this belated stage, their services could be terminated or not. it is also submitted that the principal laid down by the full bench decision is not attracted to the case in hand in the light of the factual aspect of the matters read with para 53 of Uma Devi decision. Therefore, the single judge has committed error in rejecting the requisition to Mr. Parpatan and counsel for the respondent resisted the apostate contentions and submitted that when the appellant's appointment itself is under cloud, to the extent that competent authority has not passed the order of appointment in the year 88, 89 and regularization of their services in the year 1991-1992. Therefore, there is an error committed at in their initial appointment itself. So, the learned single judge has relied on full bench decision. Hence, no interference is called for the learned counsels for the respective parties. Undisputed facts are that appellants were appointed on daily wage basis in the year 88-89. Their services were regularized.
No, in November, December 89 itself and confirmed in 91-92.
Their services were regularized in the year 1989 on different dates. Thereafter, their services were confirmed on the post on 6/11/1991, 21/2/1992 and 21/2/1992 respectively, as is evident from
notification of the Directorate of Animal Husbandry. Director Animal Husbandry at page 36, 30/12/2013.
Annexure 2 and Annexure 3 series. Further, they have been extended the benefit of ACP with reference to length of service rendered from the date of confirmation, regularization, confirmation.
My lord, may
Such ACP benefit has been extended in the month of on 1/11/2009, 1/12/2009 and 1/11/2009 respectively. In this backdrop, further, it is noticed that petitioner number 1 is due for retirement the year 2023, and petitioner number 2 and 3 have already attained age of superannuation and retired from service in the month of February 2022 and January 2021 respectively. Next, the respondents, with reference to length of service rendered by the appellants from 88 till 2016 and abruptly relieving them, terminating their services without even holding an inquiry and providing opportunity to the respective parties, proceeded to terminate their services. To stop. Full bench decision of this court is a judgment in per curiam insofar as the appellants are concerned, for the reasons that appellant's services were regularized in the year 89 and confirmed in 91-1992.
Confirmed in 2013, my lord. At
91-92. So, even assuming that it is disputed and confirmation is in the year 2000.
According to him, my lord, paragraph 18.
2002. However, ACP benefit has been extended in the year 2009. If the confirmation is under dispute, in that event, respondent have not resorted to withdrawn the benefit extended, withdrawn the ACP benefit extended to the respective appellants. In order to meet the principle of judgment per curiam, it is necessary to reproduce reproduce para 53 of Umadevi decision, which reads as under. So, in the light of observation made in para 53 of Umadevi decision, the event of any regularization was already undertaken by the official respondents. In that event, the same cannot be reopened. Therefore, the cited full bench decision has no assistance in the present case. To that extent, none single judge has committed error in refusing relief to the appellants. Next point, in the light of these facts and circumstances, appellants have made out a prima facie case so as to. No, before that, moreover, it is to be noted that having regard to the length of service rendered by the each of the appellant and the fact that two of the appellants have already attained the age of and retired from service, and another appellant is due for retirement in the year 2023, it is not appropriate to uphold the termination order dated 29/1/2016 with reference to their initial appointment in the year 1988-89, followed by confirmation in the year 1989, confirmation in the year 91-92, and extending ACP benefit in the year 2009. So the respondents have opened their eyes after more than 2 decades in ascertaining whether the appellant's initial appointment was by competent authority or not. Therefore, the appellants have made out a prima facie case so as to interfere with the order of termination 29/1/2016 and order of the learned single judge dated so and so, passed in CWJC so and so, and they are set aside. The concerned respondent is hereby directed to extend all service and monetary benefits which were due to the appellants. Monetary benefits shall be calculated in respect of each of the appellant and disburse the same along with the interest at the rate of 8% per annum. The above exercise completed within a period of 4 months from the date of receipt of this order. LPA stands allowed.
Petitioner 1 to be taken back in service. Petitioner 1 to be taken back, appellant 1 to be.
What is his name?
This is Ashwini Kumar.
Mr. Ashwini Kumar.
Paragraph 18.
Services. Ashwini Kumar, appellant, one of the appellant who has still service. What are you doing, Mr. Stenographer? You are not taking dictation. He shall be taken back to duty forthwith.
His ACP is in 2001 and 2000. First ACP 2001, second one 2009.
Kindly see, my lord.
1 second, one at a time. 2001 ACP, wherever it is there. First ACP 2001 and second ACP 2009.
My lord, kindly see, my lord, paragraph 18 of my lord, their LP. 18, 18, page 10. Confirmation is, my lord,
Page 18.
Oh, approved and confirmed by
Page 18.
page 10, paragraph 18. Service of the petitioner appellants were subsequently confirmed by letter number so and so.
approved and confirmed.
LPA.
LPA
Not ACP. Service
and
is
ACP white letter number so.
No, in LPA, para 18 is something else. You are reading from writ petition or?
No. LPA man. Page 10.
saying still a superior officer approved and confirmed the actions.
No, he is reading from which paragraph? He said
Page
18.
10, paragraph 18.
LPA memo of appeal.
Memo of appeal.
Para 18 is there. Read para 18.
Alert the services of the petitioner appellants were subsequently confirmed.
No, it is not there. You have to read that it is further relevant.
Further relevant to mention here that appointment and petitioners such as was later on approved by the regional director Darbhanga so and so were subsequently confirmed. White letter number 30/12/2013 memo number so and ACP granted in 16/1/2014.
From what date?
Date is there in Annex 230.
From what date?
Yes.
No, you should have filed your counter.
हमको काउंटर फाइल किया वो हुजूर का ऑर्डर
Senior number 8.
Your Lordship, I am appearing for the appellant.
Who is appearing in LPA 1414?
I am appearing, Your Lordship.
What is this?
Both LPA, Your Lordship, I am appearing, Your Lordship. In 1414, Your Lordship, please to direct to file an amended LPA, bringing on record the prayer with regard to the civil review also, Your Lordship. That was filed after the read, Your Lordship.
Civil review in where?
Yes,
In writ petition.
read petition, Your Lordship.
So you don't want to press this LPA?
No, now I have filed an amended LPA, Your Lordship, and as per Your Lordship order.
You can't have one in civil review and another in LPA. If civil review is already filed and it is pending.
No, that was disposed of, Your Lordship, affirming the order of the read, Your Lordship.
Have you challenged both order?
Earlier, this was challenged, Your Lordship, but as per the staff reports, our custom, Your Lordships, that was deleted the civil review order, Your Lordship. Thereafter, after Your Lordship's order dated 12/12/2020, Your Lordships, I have filed an NPA, IA, Your Lordship, for bringing on record, Your Lordship, then amendment of prayer, Your Lordship.
Amended LPA is filed?
Your Lordship, amended LPA also filed 332 of 2023, Your Lordships.
File amended. LPA new number was given. To withdraw that and file LPA amended.
You wrongly filed a new LPA. What you should have done, you should have filed an amended petition, filing counter, AO filing counter.
I have filed an amended LPA, Your Lordship.
First copy of the amended.
Your Lordship.
Show it to him. Where have you indicated in the first page that it is an amended LPA?
Your Lordship, this was not mentioned in the first page. This was mentioned
Why?
in the last page, Your Lordship.
Huh?
Last page, you have to page 7, Your
No,
Lordship.
on the first page you have to mention, no? How do you expect on the registry to know that you have mentioned in last page? On the first page, top of the High Court of Judication at Patna, above that you should have mentioned it is amended LPA.
Because as per the procedure, Your Lordship, we have to mention
So, the procedure.
that no LPA had been filed earlier.
Show us the procedure.
I have filed that the appellant earlier filed LPA number 1414, Your Lordship.
Sir, better you withdraw this and file an amended LPA. We have already given instruction to the registry how amended LPA should be mentioned and other things.
Your Lordship, permit just to incorporate one word, Your Lordship, amended.
Huh? But number has been given, no? That is the reason you should have done it. Who has prevented you?
No, Your Lordship.
Not mentioning amended LPA?
That was mentioned in my paragraphs, Your Lordship.
That is not the correct. And one more thing, which part of the LPA is amended? How we will come to know?
Your Lordship.
Which part of the LPA is amended?
And you see the page 3, Your Lordship, being agreed and dissatisfied with the order and judgment dated 2/3 early, and the civil review numbered 123. Two order has been challenged, Your Lordships.
Page number?
Page number 3, Your Lordship.
Where have you mentioned? Which portion of the earlier LPA pleadings have been amended?
Your Lordship, there is in LPA, Your Lordship, we have not pleading, Your Lordship, only question of law, Your Lordships. That was there, Your Lordships.
Sir, what is the amendment in
And
LPA?
the amendment, Your Lordship, kindly see the page 7, Your Lordships. Page 7. That the appellant petitioner has filed earlier LPA number 1414, Your Lordships, against the order and judgment dated 2/4/2018, Your Lordships, in CWJC number and filed a review of which was dismissed by this one, culminating into the order dated impugn order 2/4/18, Your Lordship. And in view of the order dated 16/1/2023, Your Lordships, passed by Honorable Mr. Sonso, to set aside the order and judgment.
Sir, IA for amendment.
Your Lordship, IA was allowed, Your Lordship, by the order dated.
Which here in this, as he indicated, this is required to be added. How to identify from your LPA, amended LPA, which portion of the earlier original LPA has been amended? How to identify from this?
Only because we have started from the being aggrieved, Your Lordship, there is added the order dated.
Sir, we are not able to understand your this thing. Have you understood what is the requirement of the court? So, assuming that we are giving you example. In original LPA, you have prayed for 3 relief, A, B, C. You wanted to incorporate one more, assuming that D prayer. Okay, D prayer is IA is allowed. Thereafter, in the amended LPA, is it not necessary to point out D has been added by the amended order? Where is that?
Your Lordship, kindly see, Your Lordship.
This procedure is available in CPC or not?
Your Lordship.
Then?
We have followed the deed petition because, Your Lordship, there is no other assessments, Your Lordships, and no paragraphs, Your Lordships. Therefore, we have started from being aggrieved from the order dated so and so.
Sir, how court will come to know which portion of the amended prayer you have sought?
If Your Lordship permit me, day after tomorrow, I will file a fresh, Your Lordships. Only this paragraph I have to amend a statement on Monday.
Where is it? 51? There are certain defects in LPA 332 of 2023. Accordingly, appellant is hereby directed to. Sorry, appellant is permitted to withdraw this LPA 332 of 2023. Accordingly, dismissed as withdrawn. LPA is dismissed as withdrawn. The appellant is hereby directed to file amended LPA in 1414 of 2018, while highlighting on the top of the LPA that it is an amended LPA, and further whatever IA for amendment of LPA was allowed. In that regard, the amended LPA in the form of subpara, and it should be indicated that such newly incorporated material information or pleadings in the LPA is with reference to allowing the IA for amendment and its date and date of the allowing the IA for amendment, comma, in such circumstances only one can understand what is the amended LPA. Otherwise, it is impossible to understand what is the amendment which has been carried out by the appellant.
So in this case, also there is
matter after 2 weeks.
issue of limitation may be done.
Huh?
Issue of limitation may arise, Your Lordships.
What limitation?
They have pointed out
414.
in 332, Your Lordship.
332, we have dismissed. Where is the question of delay? Pending IS, if any, in 332 stands dismissed, has withdrawn.
3 weeks time.
Huh?
3 weeks time, Your Lordship.
4 weeks.
No, 3 weeks. Sir.
3 weeks.
Serial number 9, Arvind Kumar Singh versus the State of Bihar for the petitioner Sri Ravindra Kumar Sinha.
Lord, by order dated 3/1/23, Lord, there was direction to the respondent to file counter affidavit, Lord. Since, Lord, there is no specific answer with regard to averment made in paragraph 21 and 22 of the petition, Lord, specifically that after, Lord, the assignment, Lord, of the work, the original work was given to this petitioner, Lord, and this was completed by this petitioner, and in spite thereof,
A fresh supplementary counter affidavit has been filed.
Lordship, counter was ready, but meanwhile the counsel for the petitioner, I have been told that he has passed away, he is no more. So,
counsel.
Counsel is no more. So, Lordship, his copy is with me. I am serving a copy to him, and the counter affidavit has already been.
What is your name?
my name is Parveen Kumar. I have filed Wakalatnama, my Lord, in this case.
Where is your wakalat? When did you file?
My name is appearing, my Lord.
Huh?
My name is appearing, my Lord.
Correct. When did you file? Where is the wakalat, Mr. Ismail. You don't have acknowledgement on what date you have filed a wakalat. You don't have acknowledgement on what date you have filed.
I have not. I will pass over one case, my Lord. I will inform, Lord, after checking yesterday. I have already filed.
एक xerox copy है. हाँ. And that too, your name is not Ravindra Kumar Sinha.
My name is Parveen Kumar.
Okay. Earlier, who was there?
Earlier,
Ravindra Kumar Sinha, he was the counsel.
The registry is hereby directed to put up the wakalat stated to have been filed on behalf of Blood Council for the petitioner, Mr. So and so. The concerned respondent is hereby directed to file supplementary affidavit in the registry during the course of the day. In the meanwhile, Land Council for the petitioner is hereby directed to carry out to attend office objection and clear the office objection before the next hearing. List this matter after 2 weeks.
But the heading for order serial number 10, the Union of India versus Eswar Kumar Jha for the petitioner Sri Anshuman Singh.
Lordship, if your Lordship may have a kind glimpse on operative part of the order, then it is most innocuous order, Lordship, also part by the principle of Aristotle.
Straight away, if you say something, we don't know what is ABCD. The file.
Lordship may seek the last order. Lordship
I am only requesting to kind glimpse on the operative part of the order, Lordship.
Sir, first of all, we should know the subject.
Lordship.
Lordships may see order number 20 and order number 19. Your Lordship.
Last time we have directed to secure record, complete records.
That is there. Your Lordships, and specifically Your Lordships had asked for the, only asked for the
Formulated certain questions. And
Your Lordships,
last.
order number 19 also may also kindly be seen. Your Lordships had also asked for the seniority list.
Have they prepared a
Yes, Your Lordship.
list?
Yes, Your Lordship. From the register, they have prepared the chart, they have brought it, Your Lordships, a copy of it. Grade 1 and grade 2, Your Lordships.
ACP, his claim is under which cadre? Skilled worker grade 1?
He wants that, but Your Lordships, he was never promoted to grade 1, Your Lordships.
Then in the senior list, his name is not there.
His name is there, Your Lordships. Your Lordships will see the skilled worker grade 2 list first. Your Lordships, in 1/1/2006, he was at serial number 6. Then, Your Lordships, on 31/3/2006.
Wait, we are not getting grade 2. We have only grade 1. Serial number?
Yeah, on the first page, as on 1/1/2006, he's at serial number 6.
SK Jha.
SK Jha. Your Lordships, then as on 31/3/2006, he moves to serial number 3. Next page, Your Lordships. Then, Your Lordships, as on 30/11/2011, he moves to serial number 2. Then, Your Lordships, as on 31/3/2013, he remains at serial number 2. Then 1/1/2016, he remains at serial number 2. 1/1/2019, he comes to serial number 1. And 1/1/20, he remains at serial number 1.
And in 1/1/2022?
1/1/2022, also he is at serial number 1.
So he has not been promoted.
He has not been promoted.
Then is he not entitled to ACP?
He's been given that, Your Lordships, the first MSCP was given on 1/9/2008. It was given on 26/11/2010 with effect from 1/9/2008. That was the initial date of the scheme. Then second MSCP has been given on 26/6/2018 with effect from 17/3/2017. And he is next on line, Your Lordships. Your Lordships will see the grade 1 list, seniority list also, Your Lordships. The person immediately before him Fabian Carqueta as
He is a scheduled tribe.
but the moment there is a vacancy, so he is come on to the grade 1, and as soon as there is a vacancy, your lordships, which is likely on 31/1/2004, he would be promoted, your lordships.
31/1/2024.
31/1/24, because the person at number 1, your lordship, Suresh Prasad, would retire on 31/1/2004, 24, sorry, not 24, 2024. And there would be one vacancy. Sorry, your lordship. As soon as there is a vacancy, he is number 1 on the list now, he will be. And
He's on number 2.
Huh? And we have also given a chart of the sanction strength and vacancy position, your lordships, of grade 1 and 2. That is the last page of the 2 lists.
Yes, according to you, you have entered the grade 1.
Lordship, I am claiming for highly skilled grade 2. Lordship may have a kind glimpse on
Grade 2.
highly
Grade 2.
I am working in a skilled worker grade 2, Lordship. A skilled worker grade 2, Lordship. After 6th pay revision, Lordship, grade 1 has been split into 2 parts, Lordship. 50% as a highly skilled grade 1 and 50% into highly skilled grade 2, Lordship. I am claiming for highly skilled grade 2, Lordship. No single person is working on the post of highly skilled grade 2, Lordship.
Where is the creation of highly skilled?
Lordship. Have a kind glimpse on, Lordship. Lordship, page 11 of the supplementary affidavit, Lordship.
Who has filed supplementary?
Appellant has filed, Lordship. Petitioner's, Lordship.
It is dated 16/8/2022.
Yes, Lordship. Lordship. In this, Lordship, page number 13 is relevant, Lordship.
No, supplementary affidavit has been filed.
13. Lordship, in this, Lordship, column number 4 may have a kind glimpse, Lordship. Highly skilled worker, Lordship. The cadre has been split into 2 parts, 50% into highly skilled grade 1 and 50% into highly skilled grade 2, Lordship.
No, which post has been divided into?
Highly skilled worker, Lordship.
Highly skilled was already existing.
Yes, Lordship.
Now, how are you entitled for this?
Lordship, thereafter, Lordship.
Where is the method of recruitment to the post of highly skilled?
It is double star is given, Lordship, and noting is just beneath of that column, Lordship. The cadre of highly skilled worker stand equally split into 50-50 and redesignated as highly skilled grade 2 and highly skilled worker grade 1, Lordship. As of now, Lordship, all the only persons are working on highly skilled grade 1 lordship. No single person has been put up under lordship highly skilled worker grade 2 lordship. I am claiming for this lordship, and the Honorable Learned Cat has passed lordship most innocuous order, has directed to only consider my case in light of the order passed by Learned Madras lordship. If your lordship may permit, then I would place the operative part of the order lordship. It is in paragraph 4. Respondents are therefore.
This has not been implemented?
No, lordship. This is not implemented, lordship. Therefore, Learned Cat has directed the respondent, therefore directed to consider the case of appellant in light of the Cat Madras bench judgment as referred to herein above and logic expressed above, and revise the pay of highly skilled worker in line with decision of 6th CPC as ordered through Ministry of Finance within a period of 3 months. When 3 months period has been lapsed, lordship, therefore after they have moved.
Appellate counsel, this has been given effect?
No, lordship.
Why?
Your lordships may come to page 11.
11 of the
same affidavit, your lordships. Now, your lordships will see at para 3827. They are unskilled worker, grade pay 1800. There is semi-skilled worker, grade pay 1800. There is skilled worker, grade pay 1900. Then there is highly skilled worker, grade pay 2400. Now, their recommended pay scale, your lordships, of highly skilled is 4,000 to 6,000. And master. And your lordships, now what has happened is the highly skilled workers, your lordships, at page 14, your lordships will see it is the highly skilled workers who have been split into two. Now, highly skilled worker 4,000 to 6,000 was the present scale. Their revised scale has been 4,000 to 6,000, 50%, and 50% has been given 4,500 to 7,000. And the grade pay has been fixed at 2,400 and 2,800. Now, it is a master craftsman who was at 4,500 to 7,000, has gone to 5,000 to 8,000.
You are not concerned with that?
No, we are not concerned. Your lordship, now this highly skilled worker, that has been split into two. The petitioner, the writ petitioner respondent was never a highly skilled worker.
No, sir. Just down below that.
Just your
cadre of highly skilled.
Your lordships may permit me to complete. He was a skilled worker in 3,050 to 4,590, drawing a grade pay of 1,900. Now this was left untouched. They did not, the commission did not touch this. They remained at that only. And your lordships is seeing the asterisk. The cadre of highly skilled worker stands equally split. Now, he was never in the cadre of highly skilled worker.
No, it's all right. Read further.
50, I redesignated as highly skilled worker grade 2, pay band 2,400, and highly skilled worker pay band 2,800.
What has been redesignated?
Redesignated, your lordship, the highly skilled worker who was present pay 4,000 to 6,000, grade pay 2,400.
Redesignated as what?
They were redesignated as highly skilled worker grade 2. Your lordships, redesignated as highly skilled worker grade 2. And this cadre of skilled workers, they remained, that was untouched. Now the confusion that is sought to be created by the writ petitioner respondent is that he comes under that. How would he jump when he is been left untouched, that grade? 1900 grade pay has been left untouched. And his avenue of promotion, your lordships, I have shown. And your lordships will see that this seniority list is also skilled worker grade 2.
Mean to say that out of highly skilled worker, 2 more cadre was created, namely grade 1 and grade 2.
Yes, that was
not the skilled grade 2.
No, it was that one cadre who was drawing 4,000 to 6,000, pay band of 2,400. That was split. Half went 50% and remained at 2,400, and half 50% went up to 2,800. And this 1,900 was left untouched.
Lordship. As of now, Lordship.
Read once again.
Lordship.
Cadre highly skilled was bifurcated into two. 50%.
Yes, Lordship.
Read that.
Yes, Lordship.
So that your cadre is incorporated.
Cadre of highly skilled worker.
Stop at that. First, the cadre of highly skilled worker stands equally split into ratio of 50-50. He designated as highly skilled worker grade 2 and grade 1. It is not the skilled workers. Grade 2 has been redesignated as highly skilled worker.
Lordship, earlier only 2 grades as per appointment rule, Lordship. There was only 2 grades. Skilled worker grade 2 and skilled worker grade 1, Lordship. There was no post of highly skilled worker, Lordship. After this recommendation, Lordship, highly skilled post of highly skilled worker has been created, and all the persons who fall in the
where is the highly skilled? What is the method of recruitment to the post of highly skilled worker?
No, there only as per equipment rule, which is before Lordship, there was only 2 posts, Lordship. A skilled worker grade 1 and a skilled worker grade 2. A skilled worker grade 1 is the promotionary post, Lordship, and entry grade was a skilled worker grade 2, Lordship.
Now, how the person will enter into a highly skilled worker?
Lordship, there is no definition of that in this, Lordship. Lordship, but
then have you prepared seniority list of highly skilled worker?
Because it was
not required. It is not a highly skilled.
Then how are you?
But a highly skilled worker.
All right, sir. How are you going to fill up highly skilled worker grade 2 and grade 1?
Highly skilled worker, your lordship, grade.
more submission, Lordship, if you permit, Lordship.
We are asking something.
Highly skilled worker, your lordship, says I. That would be, your lordship, from the cadre of highly skilled worker. Cadre was already there.
Correct. Where is that? How? What is the method of recruitment?
That I.
Recruitment rule, highly skilled worker. Highly skilled worker is skilled worker grade 1. We entitled
Learned CAT has only directed them to consider my case in light of Chennai CAT order, Lordship. Nothing beyond that, the order has been passed.
What we should do?
इसमें नहीं
They have moved for extension of time for compliance of that order, Lordship, before learned CAT Patna, Lordship. That is on record also.
So you will adjourn the matter?
No.
Then why are you making all those submissions?
I'm sorry.
Go to grade 1.
This is 4,000.
How is the entry of this?
Selection record. One promotion. Grade 1 will become one promotion.
Your Lordship, this skilled worker grade 1.
No. We are asking you highly skilled worker, how the post was generated and what is the mode of recruitment? Is it by direct recruitment? Is it by promotion? Or is it by appointment by transfer?
Lordship, he says it is by promotion, Your Lordship.
Where is that? Promotion from, which is the feeder cadre?
Grade 1. Equivalent to grade 1. Grade. Please skilled worker. In their MSME.
Lordship, he says in MSME, skilled worker, highly
skilled worker grade 1 is
skilled worker grade 1 is equal to drawing 4,000 to 6,000.
Sir, we want only what is the mode of recruitment to the post of highly skilled worker?
It is the same paper.
हाँ same paper book के पास भी है
उनको दिया है
Lordship, this has been submitted before the court as a not as by way of affidavit but given on one of the.
Where is that? If you have a copy, you pass on.
We have this one copy. Highly skilled worker.
No, this is skilled grade worker. We are concerned with the highly skilled. Highly skilled worker, how the post would be filled up. First of all, on what date it was created? What is the method of recruitment? Is it by direct recruitment, promotion, appointment by transfer?
ग्रेड पे देखने से इक्विवेलेंट
This copy we have.
Yes.
ग्रेड पे से लेंगे.
हाँ ग्रेड पे से होगा ना.
As of now, Lordship, all the persons who were working in a skilled worker grade 1 has been given benefit of highly skilled grade 1, Lordship, and no single person is working on highly skilled grade 2, Lordship. Therefore, I am claiming for highly skilled grade 2, Lordship. My promotionary post is also grade 1, Lordship.
Lordships, the skilled worker grade 2 with 8 years of regular service in the grade is eligible for promotion to the post of instructor. That is skilled worker grade 1 in the pay scale of 4,000 to 6,000 pre-revised. That is the same as the highly skilled.
Huh? We are not concerned with the scale. Which scale is equivalent to? We want to know how a person will enter into a highly skilled worker.
Highly skilled worker, Your Lordship.
Sir, that post is created by which order? Who is the official who is come here?
He is.
You don't know? Where is the document?
In our ministry, there is no highly skilled grade 1.
Highly skilled worker post was generated in your department on what date?
Not this. Not generated.
There is no creation. Then how this
This is CCS.
this has been bifurcated?
It is CCS.
Workshop staff, highly skilled worker. You are saying no.
My Lordship, skilled worker grade 1 is equivalent to highly skilled worker.
Have you seen the document which you have produced? Along with the supplementary annexure 12, page 13. Show it to him, sir.
डिफेंस का लगाए हुए हैं
Ministry of Defence.
And what is the method?
Highly skilled worker, master craftsman.
Further, it has been bifurcated.
Lordship, he is saying that no single person is working on highly skilled worker, but in petition, Lordship, at page number 17, he is taking reference that skilled worker various remedy has requested for division of.
What we should do? What we should do? Huh? Blindly we have to give direction, is it? I don't know why. They are relying on.
एक्सट्रैक्ट जो है ये नोटिफिकेशन हुआ ठीक है This doesn't have this CPs. CPs rules. And they have a title. Okay. ये खाली डेमोन्स्ट्रेट ये जो पेमेंट है इसको छोड़ के इसके ऊपर किया गया इसको स्प्लिट कर दिया गया This was
Your Lordships, it appears, I will clarify it, I'll make further this thing, I'll file an affidavit, but it appears what has happened is this 6th pay commission, Your Lordships made these recommendations which Your Lordships have seen at page 11. And in this, Your Lordships, this applied to all departments, not specifically this department. And then skilled workers in the pay band of 1900 were left, highly skilled. The equivalent pay and pay band 2400, that was split up in 50%, Your Lordships. And that is page 13, Your Lordships, was the notification. And page 14, Your Lordships, is the amendment in the CCS rules. Now, this ministry, this department of MSME does not have a highly skilled worker.
They don't have highly skilled?
No, they don't. That's what he is saying. They don't.
We will say it on affidavit.
We'll bring it on affidavit.
We'll bring it on affidavit.
No problem.
Then this annexure 12 is relating to which?
This is just there is an amendment. When in CCS RP rules.
This is this annexure at page 14, Your Lordships. This is just to show that there was an amendment, and he is claiming this, which is not applicable.
That is the reason, if your department, in a particular department, these are the cadres. You point out that the highly skilled worker post is not at all existing in your department.
That is what we'll bring on affidavit.
You yourself creating problem, producing annexure 12 and 11.
That was demonstrated.
That was to demonstrate, because this is what he had claimed.
Which is the parent department of the petitioner?
Medium and small.
Medium and small. Micro, small and medium.
You file an affidavit stating that in so and so department, the post of highly skilled worker is not existing. So that we can straight away reject his claim.
Your Lordships, possible may come in the order.
Indicated, Lordship. Maybe indicated in order, Lordship. If Lordship.
Further matter was heard at length in the presence of an official of the department, Mr. So and so. He had given instruction to the senior counsel that the post of a highly skilled worker is not existing in the department of MSME. And it has been, and the post of highly skilled worker is existing only in the Ministry of Defence.
In other ministries, other ministries, not this.
No, from Annexure 12, one can draw inference. It is existing in Ministry of Defence.
It is there, but it may be in other departments.
But not in this ministry.
We will not say only defence.
This is an independent ministry, Your Lordships.
We will not say only defence. It may be in other ministries.
Ministry of Defence or War, Allied Department of Ministry of Defence. To that effect, competent authority is hereby directed to file an affidavit stating that the post of highly skilled worker in the pay scale of rupees 4,000-6,000 and revised to 4,000-6,000 PB-1 grade pay of 2,400 to step further. The post of highly skilled worker was split in the ratio of 50-50, while redesignated the post of a highly skilled worker as grade 1 and grade 2, grade 2 and grade 1 in the grade pay of rupees 2,400 and 2,800 respectively. If such post is not available in MSME, in that event respondent has no case. This matter after 2 weeks.
It will come up. What? Okay.
Serial number 11, the Union of India versus Srimati Rameshwari Devi for the petitioner Sri Radhika Rani.
May it please you, my lord, the order dated 14/2/23, my lords, has been complied with by depositing cost, my lords, and second supplementary affidavit has been filed in compliance with the order dated 2/8/2022, my lords.
Have you complied the 2/8/2020 order?
My lords. Cost has also been deposited. It was deposited on 23rd February, my lords, And second supplementary affidavit has been filed, my lords, which answers your lordship's query, my lords. Para 7 of the second supplementary affidavit.
What is the date of supplementary affidavit?
It was filed on 25.
Left the court in the lunch hour. So by prayer, my lords.
After 2 weeks.
Serial number 12 versus Devi Shakti and Company versus the state of Bihar for the petitioner Sri Ranjay Kumar Singh.
It's after 2 weeks.
Under the bidding for admission, serial number 13 versus Aditya Tiwari and Associates Private Limited versus the state of Bihar for the petitioner Sri Praveen Kumar Sinha.
Must have become infectious.
Of the same road, they gave tender to different contractors.
अभी एपिडेमिक 12 का मतलब
Case for the petitioner. Matter is of the year 2015. Hence, writ petitions stand dismissed for non-prosecution.
Item number 12, your lordship.
Huh?
Item number 12, your lord.
It is already adjourned by 2 weeks.
Lord, in that case, my lord, already direction was given to file
We
counter.
have already adjourned the matter, sir.
My appearance, ma'am.
It's in number 14.
Serial number 14
Milord.
is adjourned for 2 weeks.
14 is adjourned.
15 and 16 are also adjourned for 2 weeks. Serial number 17, DBG India Limited versus the state of Bihar for the business to distribute Sharan Pandey.
May I submit? एक second, sir. In this case, Lord, I appear for the respondent State Health Society by which the NIT was published. 4 days back, this voluminous counter on behalf of respondent 6 who was qualified in technical bid but lost in financial bid. So there are so many voluminous documents and the allegations are from para 8 to 18 against me. So my officers is there and I have been instructed a reply is being prepared. So sometime if I reply, otherwise it would deem to have been admitted.
Sixth respondent counsel seeks time to file objections. Matter after 3 weeks. It is made clear that no further time
Yes.
is granted.
Yes.
Serial number 18, Ashok Enterprises versus the state of Bihar for the petitioner's Leonid.
Matter, my lord. The petitioner is a transporter. He used to take grain from the godown of the SFC and he provides it, transports it and provides it to the fair price dealer. In this case, on 9th of October 2022, a viral video has been made on the internet by which a truck was found to have been displacing the grains somewhere else.
So what is this? Memo dated 10/10/2020.
Yes, my lord. Pardon?
10/10/2022 memo.
By order dated 10/10/2022, the tender which were with the petitioner has been withdrawn by the authorities. And my lord, at a page number 53, my lord.
Page number 50.
51, my lord. 51.
My lord, annexure 7.
No, 51, 10/10/2022. 51 page number. Annexure 5. By this order, the tenders which were given to the petitioner earlier were taken away and it were given to other persons on the allegation that a viral video is there on the internet by which a truck has been found wherein the grains were taken by the SF from the godown of SFC, but rather than providing it to the respondent number 6
has been given.
Yes, my lord. Yes.
Notice has been given.
Yes, my lord. Notice has been made to respondent number 6. They have appeared.
Sir, before withdrawal of this tender award of work, you have been issued a notice.
No, my lord. On 9th of October, the viral video came on the internet. On the 10th of October, same has been withdrawn.
How can you pass without providing opportunity?
Transport, Notice, my lord, issue after, my lord. Kindly see in annexure 7, page 52, my lord.
So what is the effect of quashing 10/10/2022 and 4/11/2022?
That letter is, my lord, hand over the transporting over another transporter, my lord. Decision is annexure 7, page 53, my lord.
All right, sir. Without giving opportunity to him, you have.
My lord, 7/11/22.
How can you issue after 10/10/2022 notice when you have already terminated? Now, who is operating?
My lord,
Appellate authority, my lord. Appellate authority, my lord, MD.
No, who is operating? Whether he or a third party?
Third parties they have given tenders to other persons.
Because he has not been heard.
My lord, one simple, my lord. Statutory remedy.
Already created.
What was your period for which you were given this contract?
For 3 years from the date of the assignment, and that ends on 1st of August 2023. From 1/8/2022 to 31st of July 2023. This is my period.
My lord, humble submission, my lord. Statutory remedy for appeal, my lord, before the MD, my lord. As per decision by the District Transport Committee, annexure 7, page 53, to decide to terminate the petitioner's agreement, my lord. That order challenged before the Appellate Authority, my lord, MD, BSF. Annexure 7, page 53, my lord.
There is no provision by which this order dated 10/10/2022 can be challenged before any appeal.
All right. What is the effect of quashing annexure 5?
My lord, because they are making transport.
Correct, sir. We will quash it. How are you benefited? Because third party right has already created.
They have been given them on temporary basis. They have not made any agreement with them. They are providing it. They are allowing them to act on temporary basis.
That person has already executed document, my lord, and continue to transporting work, my lord.
On that day, there has
allotted to
Sir, after cancellation of the petitioner's work contract,
my lord.
have you invited fresh tender?
No, man. That temporary, my lord. That work is allotted to the present contractor, my lord, in the district, my lord.
That can be withdrawn, no?
Yes, my lord.
That can be withdrawn because it is not with reference to fresh tender.
My lord, the petitioner, if my lord, annexure 7 not challenge, my lord, annexure 7, my lord.
Annexure 7 is what?
Termination order, my lord.
Subsequently, they have terminated B.
Termination order, my lord. That order not challenge, my lord.
That is also impugned in this writ application, my lord. Because that is the
challenge 4/4/2000.
Yes, exactly, my lord. In this writ application.
2022.
Yes, my lord. In this writ application.
Challenge.
My lord, as per statutory remedy to appeal, my lord, file.
Appeal is also filed.
Not filed, my lord.
Then insofar as 4/11/22 is concerned, appeal, it is an appealable.
My lord, statutory remedy is appeal, my lord.
Under which provision?
MD, my lord, before the MD, my lord.
Correct, sir. Where is the law which requires that he has to file appeal?
My lord.
Anyway, we will not ask him to file appeal because it is without notice. Violation of principle of natural justice.
Okay, my lord. Without notice, my lord.
Huh? Yes, sir. Where is the petition? Huh? As usual.
My lord, remand back to the transport committee.
For sixth respond. You have no right.
As per annexure 4 lordship. Receive the bench lordship.
Correct, but he has not been provided notice in annexure 5 and in annexure 7 there is no reference to his contention against the show cause notice. Yes, take on. Instant petition petitioner has prayed for the following relief. Petitioner was a successful bidder insofar as the providing transportation.
Transport come handling agent, my lord.
Transport?
Come handling agent.
Transport come handling agent. Muzaffarpur. Such a contract was for a period of 3 years. So before completion of a 3 years period, contract was terminated on 10/10/2022 based on the allegations that petitioner was manipulating something and it was noticed through video clipping. However, termination of contract is based on serious allegations and petitioner has not been provided opportunity of hearing before passing order on 10/10/2022 via annexure 5. Next file. Insofar as challenge to the order dated 4/11/2022 communication via annexure 7, even though it is after notice, however, perusal of annexure 7, there is no consideration of petitioner's reply to the show cause notice. Both annexure 5 and annexure 7 are amenable to review.
My lord, one submission, my lord. One submission, my lord.
It have been reasoned order after giving due opportunity of hearing insofar as annexure 5 dated 10/10/2022 and further decision on 4/11/2022 to stop. Next file. Appeals court in the case of Kranti Associates in para 47, it is held as under. The principle laid down by the appeals court in the aforementioned decision is attracted for the reasons that both annexure 5 and A7 are amenable to judicial review. In such circumstances, order decision must meet the principle laid down in the aforementioned decision. Accordingly, the petitioner has made out a prima facie case so as to interfere with annexure 5 and A7. They are set aside, reserving liberty to the concerned respondent to proceed in accordance with law after giving ample opportunity of hearing to the petitioner. So in the meanwhile, the petitioner shall be permitted to execute the work allotted to him till a final decision is taken. For the reasons that interim arrangement has been made by the respondent and not resorted to fresh tender process. The above exercise shall be completed within a period of 3 months from the date of receipt of this order. Resolution allowed.
Item 13, my lord. I was sitting in my lord's court throughout from 11 to 1:30, my lord. But my lord, just for a minute.
You can't mention when certain proceedings are going on.
I'm sorry, my lord. I'm sorry, my lord. I'm sorry, my lord.
My lord, in serial number 19, the concerned advocate has requested the adjournment for 2 weeks, as he is.
Serial number 20, H.N. Kumari versus the Union of India for the Petitioner, Sri Gautam.
May I please, Lord? Petitioner had come before your lordship for payment of lump sum ex gratia compensation amount, lordship. The husband of the petitioner was a traffic porter in railway, lordship, and during
traffic
porter at railway crossing 54A Hajipur, lordship. Earlier also, your lordships were pleased to hear this case and order the respondent to file counter, lordship. They have filed also.
Where is the scheme of compensation?
My lord. That is annexure 5 and 5 by 1, lordship.
5?
5 and 5 by 1 of my petition, page 41, lordship. And
41?
My lord. Of main petition, lordship. Read petition.
First of all, you are an employee.
My lord.
Huh?
Yes, my lord.
What traffic?
Traffic porter.
Porter.
Traffic porter.
Yes, my lord.
Yeah, an employee.
Right.
Then why he has not been extended?
My lord, although the remaining benefits have been given to him, the late Sri Kumar, who died, he was appointed in the year 2007 and written my lord, and 1.5 years after, my lord,
Died on 24/12/2009.
He died, and this is very surprising, my lord, that lordships may kindly see it is written in the session diary. Although the benefit frequently para 3 subpara 2 of page 2, my lords, of counter affidavit after the.
No, what is the reason for not extending the compensation?
Lump sum ex gratia was not given to him.
What is the reason?
Yes, the reason is that the mandatory is that since it is alleged that it was unnatural death, so FIR was must to be done. Number one. Secondly, postmortem was essential, my lords, which was not done.
He says accident.
No, my lords.
A snake bite, lord.
Huh?
A snake bite.
Suspected bite. It is said that suspected.
Evidence, snake bite.
My lord, that is in Annexure 1 and 2, lordship, and in their counter itself, they have accepted that he died due to snake bite, lordship. Can you
We
see, lordship?
have not accepted it. My lords, your lordships may kindly see.
Lordship, your lordship may have pleasure to see Annexure R/3 of the counter filed by the respondent, lordship.
R/3?
My lord.
R/3 is simply provision, my lord. We are not denying that ex gratia lump sum is not to be paid, but the essential is to file a FIR to show that what was the reason of the death. My lord.
Who is the author of Annexure R3?
My lord, this is the doctor, lordship. Lordship, bottom I am reading, lordship. Found him dead due to a snake bite, lordship. This is annexure of the opposite party lordship. Before that also lordship annexure R1 may kindly be seen lordship.
No, which is the spot?
No lordship, it is
He died
in hospital lordship. First he
sir, snake bite was?
at the birthplace lordship.
Birthplace?
My lord, the railway crossing lordship 54A lordship, that is railway crossing number 54 accepted lordship. R1 is written lordship.
No, he is not a government doctor. Dr. Y.K. Thakur.
And my lord, everything will be clear lordship. First read annexure R by 1 placed by the opposite side lordship. And annexure 1 and annexure 2, that is there some record lordship, clearly stated that died due to a snake bite lordship.
No, it is not. Your Lordships, I may be permitted to state the real state of affairs, my lords. Actually...
No, annexure R1 is, who is the author?
स्टेशन अधीक्षक पूर्व मध्य रेलवे हाजीपुर अभी प्रमाणित लॉट
R1 is a station diary, my lord, where it was informed that someone is conscious, gateman at 54 A gate, the gateman is unconscious. And when they sent there, they were informed that the local persons, someone had taken him to the Sadar Hospital. Sadar Hospital, the report of Sadar Hospital may kindly be seen, R2, at page 33, my lords. At page 16. This is the prescription of Sadar Hospital, who referred, your officers may kindly see in the last, or the suspected snake bite, as the persons carrying the late Sudhir Kumar informed that probably...
What was the age? What was the age?
30 years, my lord.
Then if you are suspecting that it is not a snake bite, then what is the outcome? On what basis he died?
My lord?
Sir, he is aged about 30 years.
Yes, my lord.
What is the natural death? What is the cause?
Suspected snake bite, but whether he was poisoned by someone or whether that was the heart attack, due to the...
No, they are saying that snake bite.
They are saying, but no one is confirming, my lords.
According to you, who has to confirm?
My lords, the postmortem was required to confirm the reason of snake bite, my lords. Snake bite or the reason...
No, he has died in village and all post-mortem. Where is the question of post-mortem?
Yes, my lord. There was question of post-mortem. Your lordship may kindly see...
Sir, in village, can you subject him to post-mortem?
No, Hajipur, my lord. In Hajipur...
He died in Hajipur.
There is a Sadar Hospital and they went there. Preliminarily, they were treated in some unconscious state.
Correct,
they
but...
went there and they referred them. Lastly, referred to medical examination PMCH, medical emergency PMCH Patna for specialized management. Had they gone to PMCH, then certainly after death, when the postmortem was due.
They are illiterate.
No, my lords.
They are literate.
But they had gone to the Sadar Hospital, my lords, where they were referred to they were illiterate. They could have contacted the concerned railway administration. My lord, this is very surprising that someone, and the hot haste, they made it cremation, last rites.
We have replied in...
At about 11 a.m., my lord, he was found unconscious, and at 2, he gets a medical certificate by a pediatrician, not a medical...
What is the date of his death? He died on what date?
My lord, 24/12/2009 24th December 2009, lordship.
What is the date of your application for the compensation?
My lord, I have stated.
2013, my lord.
Before that also I have made many applications, lordship, but
Show us one application in the year 2010.
in para 6 I have stated, lordship.
Your statement is not sufficient.
My lord, that is an excerpt, lordship. Skip.
Is there any application demanding compensation in the year 2010?
And lordship, they have given appointment to the petitioner on compassionate ground, lordship. They have themselves accepted everything, lordship, but now on this matter they are denying the fact. Kindly see, lordship.
Compassionate appointment to whom?
His wife.
The petitioner, lordship.
It was given.
My lord.
His office superintendent rejected.
That is sufficient. Why compensation? Because the compensation application is not within the reasonable period of time.
My lord, I have a next and extra three lordship.
This was the reason why the case
has made before the authority concerned, lordship, on very technical ground. That is not everything. 24/9/13 का application, lordship. 24/9/13, that is annexure 3 at page 34, lordship.
Snake bite was at what time?
My lord, that is also they have written in counter their counter, lord.
What counter? You have to say.
It was duty hour 8 बजे से 16 बजे के बीच का टाइम लिखा हुआ है वो.
My lord, it is very surprising. They avoided to
After death of this employee, how much you paid to the wife?
This is page 2 of the counter I will make and receive. After the death of late Sudhir Kumar, DCRG, death retitle gratuity of rupees 56,607, leave encashment of, since less than 2 years he had completed his job, leave encashment of rupees 19,340 and general insurance rupees 15,305 and family pension applicable under the old pension scheme in this case were paid in favor of wife Mrs. Kansan Kumari, that is petitioner. Further, she was also granted compassionate appointment and at the present she is office superintendent in commercial department.
Certificate is genuine.
Their first representation for
Engineering document or? I don't know the procedures. He died in hospital. Doctor will issue a certificate. As he admitted in this hospital, he is due to sleep. He was admitted in the hospital. Same. I have examined his so on 24th of December about 2 p.m. and found he is dead due to sleep. Given that you is authentic. Normally they would like died due to sleep, but just most can say that he died. Dead due to sleep, but the language. No, 5 lakhs. It's not 10 lakhs. As on the date of 2009. Due to defective document. Only we have to rely on this document. The related time. How do you explain delay? Delay. 2009 death, 2013 or 14?
I have always consulted the authority concerned by giving applications, Lordship.
Was one application, sir, 2010.
13 of 2013, that is before your Lordship.
2010.
That is not present.
Then you are not entitled. After 4 years is nothing but.
And Lordship, Annexure 8 may kindly be seen, Lordship.
Tail claim cannot be entertained.
Annexure 8 may kindly be seen, Lordship. 8, Lordship. Similarly situated person on the ground of delay had been paid, Lordship, by the order of the CAT, Lordship. Annexure 8, Lordship. That starts from page 8, Lordship, and the relevant portion is page 63, relevant portion, Lordship. 63, Lordship.
What is the date of death? In the Renu Devi case, what is the date of death?
हम केवल एक
1/3/2012.
Lordship, हम केवल एक पैराग्राफ I am placing before your Lordship. Only one paragraph, Lordship. Hence, denying such benefit on technical grounds, even when there is no doubt about the occurrence of the eventuality, entitling the grant of such lump sum compensation is against very letter and spirit of the scheme. I therefore direct the respondent authorities to release the applicant the ex gratia payment payable in case of death of an employee occurring due to accident in course of performance of duty within 3 months from the date of issue of this order. The OH disposed of this order accordingly. So they are taking a very hyper technical ground, Lordship, that
sir, 4 years can't be condoned, sir.
But we were approaching, Lordship.
What is the date of compassionate appointment application?
That is not presently before us, Lordship. But we have.
Appointment was given on what date? Because that you don't know. What is the date of compassionate appointment?
That is also not with presently with. But they will answer that when they have provided.
They have not come to the court. You have come to the court.
My lords.
Answer.
Sorry, Lordship. That is, but just after some time they have given.
Then when you can ask for compassionate appointment, why you did not agitated for compensation? That shows that you have created document.
Petitioner has always agitated, Lordship. They are annexure of 13, Lordship. That is annexure 1 and 2, Lordship. The railway higher authority have given this document, Lordship, annexure 1 and 2, Lordship, clearly stating अकेले गेट पर अपने रोस्टर के अनुसार ड्यूटी कर रखा था और उसी में लिखा हुआ है कि रोस्टर के अनुसार ड्यूटी करते हुए सांप काटने से मर गया.
No, compassionate appointment was given on what date?
Exact date I cannot say.
There are no pleadings.
But immediately after the death of the compulsory appointment.
So we have to presume immediately.
No, my lord.
Then how can you make such submission? Very vague submission. That is relevant for the purpose of claiming compensation. In order to see the conduct of the petitioner,
Maybe adjourned for a short date, my lords. I shall give the exact date of his compulsory one.
counsel for the respondents are hereby directed to apprise the dates and events in respect of compassionate appointment application and use of order of appointment to the petitioner on the next date of hearing. In the meanwhile, petitioner is hereby directed to produce any document to show that she had requested for compensation in the year 2010. 4 weeks.
CL number 21 versus Krishna Construction Company versus the State of Bihar for the Christmas tree and for
Annexure 1 is under challenge, my lord, by which, my lord, without calling any explanation and without grant of an opportunity of hearing, petitioner along with others, my lord, whose contractor has been debarred, my lord, from further participating in any contract, my lord. Annexure 1 is at page 10, my lord. Petitioner is concerned, my lord, with respect to item number 14 and 15. MS Kinsakar.
Sir, is it without notice? Sir.
My lord, so now, my lord, the annexure 2 has come. 2 has come. That for certain works under the agreement was not completed. Now he has completed the work. And he approached the executive engineer. Executive engineer has said that the work has been completed. Now the order is required to be, my lord, passed by the engineer in chief. So this petitioner has to go there. He has not gone there, and there the order will.
So first of all, Annexure A1 is after giving notice to him or not?
My lord, those notices are given, but those notices are given.
Then where is the reference in Annexure 1?
My lord, those notices were given by the executive engineer and by.
Sir, whoever it may be, where is the reference in Annexure 1? That on so and so date notice were given, he has submitted his reply. His reply is rejected for this.
My lord, those I have to bring it to the counter affidavit. But my lord, because it's a recent case, my lord, 23. I'll file the counter. But we
one relevant fact, my lord, annexure 3.
Because 2 is there, my lord, we kindly see, my lord. Annexure 2 is there. He has been recommended. But the executive engineer, my lord, who has recommended him, who has asked, he has given the notice.
No, there is no reference to notice.
No, last line is, my lord will say the second.
Where is his reply to
second paragraph, my lord.
Has he filed his reply? To the notice.
No, this
Contract is completed, the work taken out of the work list.
Annexure 2 is not.
We'll ask them to take decision within 4 weeks or something.
We'll set aside annexure 1.
I'll file the counter affidavit.
No, 1 second. We'll set aside the annexure 1 and we'll direct the concerned authority to act on annexure 2 within a period of 8 weeks.
But the process, my lord, that will be that will suffice, my lord. But the process is that the order is passed by the engineer chief. He is the completed at all, my lord. Once he has completed the work, my lord, that is the recommendation. He applied for the before the engineer chief, and the engineer chief an issue because it is not a permanent. It is the debarred is only with respect to when his work has not been done, he was debarred. But the work is done, that has been withdrawn. This is all been done.
Oh, annexure 1 has been withdrawn.
Annexure 1, my lord, since the recommendation is there that he has completed the work and he had given a NOC, then my lord on that.
That is the reason we will set aside annexure 1 and directing the concerned authority to pass order
that will also
recommendation.
My submission is, my lord, once he will approach the engineer chief, this order will be automatically withdrawn because there are several persons, my lord, who have been not.
But you have already sent a recommendation to superintendent engineer that he should be taken out of
yes, my lord. And to the superintendent engineer, my lord, and since the order
is there
passed by
further need for him to go to the engineer in chief?
The order has been passed by the engineer chief. The engineer chief has withdrawn the order is being withdrawn by the engineer chief. That is the only part. But my lord's order will comply.
Your lordship permission, one important vital fact, my lord. One important fact I would like to place before lordship annexure 3. While this such type of matter were was being heard by the single bench, my lord, the annexure 3, my lord, the same annexure 1 was under consideration with respect to another my lord contractor, since several contractors have been debarred, and that annexure 1 partly had been set aside, my lord, passed by annexure 1, my lord, in CWSC 1339 of 2021, my lord, while order dated 7/10/2021. Consideration part will start from page 31, my lord, where in even this letter dated 13/7/2021.
Ultimate decision. We are giving extra.
Or my lords will grant me some time file counter. In the meantime, I'll ask the engineer in chief, my lord, to act upon.
All these things we will dispose. Yes, take down. In the instant petition, petitioner has prayed for the following relief. To stop perusal of annexure 1 dated 13/7/2021. It is not a reasoned order, and so also the petitioner has not been provided an opportunity before impugned action at annexure 1 is taken. To stop insofar as challenge to order dated 4/11/2022. Sorry, insofar as annexure 2 4/11/2022, the concerned authority was required to take necessary steps with reference to the recommendation. To stop. In the light of these facts and circumstances, annexure A1 stands set aside.
Annexure 1.
And further, annexure 1.
Respect to the petitioner, my lord.
So far as petitioner is concerned, to stop. Annexure 2 Stated. The concerned respondent is hereby directed to take a decision at the earliest, not beyond 3 months. Accordingly, the present petition stands goes on. While giving opportunity to the petitioner.
Serial number 22 versus Star Construction, Valua, Tal Murihani versus the State of Bihar.
Lord, there is provision, Lords, if only one tender Lords declared as qualified in technical bid, then the tender re-tendering shall be held. Lords, here in this task case, Lord, the 3 persons were declared Lords eligible, technically qualified. Thereafter, financial was opened. I was declared as L1. After 4-5 months, he again held up a technical bid. And 2 persons who were earlier declared qualified and my financial was opened, they were declared non-responsive and thereafter the tender has been cancelled.
Which is the document to show that you have been declared a successful bidder?
My lords. My lords, the financial is, my lords, annexure 4, page 22. And thereafter annexure 5, annexure 6. Annexure 4 is the financial bid. I am at the top, 15.79. It is quite small, my lords. Next page, my lords, page number 23. I wrote application to the executive that I have been declared L1. Kindly execute agreement. Thereafter, my lord, the executive engineer on page number 26. He recommended to the superintending engineer that this petitioner has been declared L1. Therefore, he recommended for execution of agreement. Thereafter, my lord, the next page is the superintending engineer wrote letter to the chief engineer that I have been declared L1. Therefore, agreement to be executed. And thereafter, again, technical bid he held.
Who?
The executive engineer, my lord, the technical bid committee, my lords, annexure 8. And the financial opened and the 2 persons who were declared, my lord, the L2 and L3, they were declared non-responsive and thereafter the re-tendering process has been initiated. They cannot do it, my lords, in view of the amendment of the year 2016.
Regard to that, notes instruction from the respondent concerned to file.
Concerned respondent is hereby directed to file for the next date of hearing. In the counter affidavit, he must point out which is the relevant clause which permits him to revive the financial bid, proceed to once again undertaking technical bid while defeating the alleged right which has already created in favor of the petitioner. Release this matter after 3 weeks.
Lords, the status quo in the meantime.
Huh?
The status quo in the meantime, Lords. Nothing has happened.
Status quo is maintained.
Till date, that is maintained, Lords. That may kindly be maintained by my Lord's order, Lords. They issued fresh tender, but nothing has happened till date, Lords.
Fresh tender was issued.
Was issued, but nothing has happened.
But you also participate.
No.
No, sir, you also participate.
No, my lords. They
subject to.
No, I submitted application. Thereafter, they are not proceeding further. I filed application before this Honorable High Court. I informed them that matter is sub judice, so they are not doing anything. But my lords will indicate.
Fresh tender, if any, proceeded by the official respondents, is hereby stalled until the next date of hearing.
Obliged, much obliged.
Technical.
Serial number 23. Rai versus the Union of India for the Express India.
May I please, Lords?
Directive 3 है sir.
Which is the clause which requires that you have to deposit
Yes, my lord.
second license?
Yes, my lord. That is the provisions in the advertisement itself. Have to point it. But in this.
Correct, sir. Which is the clause?
Yes, my lord. I am giving the clause. Annexure 1, my lord, in the advertisement itself, not the allotment order, page 13. Further, paragraph 2.
Sir, your license has been cancelled on the score that deposit second license fee.
Second license fee.
Where is the provision?
Yes, that I am. Second license fee. That I am placing, my lord, before Lordship, my lord.
That?
Annexure 1, page 15, work order. Further, you have deposited the first installment quarterly license for amounting to rupees so and so, including GST, white so and so, towards the contract. Deed sheet as well as contract has been signed by so and so. You have to profile, however, for the ready reference with the view of above contract, parking and four-wheelers are being given to you.
For the railways?
And rule provides, my lord, clause 10, before cancellation 30 days. Oh, I'm sorry.
First installment, yes, please.
After 2 weeks.
And my second point is, as per the rule,
You have to highlight which is the relevant provision.
Yes, sir.
Serial number 24, Lalan Kumar versus the State of Bihar for the Christmas tree account.
May it please your lordship. Lord, in this writ application, Lord, the rejection of my technical bid is the subject matter of the writ application, my lord, which has been rejected on a very flimsy and honest ground, my lord. Annexure 1 at page 16, if you lord, the work tender, the notice inviting tenders, my lord, was taken out, my lord, for the repair of roads and maintenance for another 5 years, my lord. Now, I had maintenance of roads, the rural roads, my lord, and my lord, for 5 years to upkeep and maintain it for next 5 years. For this, my lord, the tender was issued, my lord. If your lordship will directly come to page 16, which is the impugned, my lord, annexure. Page 16, my lord, on the technical bid, my consideration is at serial number 3, my lord, the Lalan Kumar. And he, my lord, very vaguely says, my lord, ki your this has been rejected, technical ground has been rejected on the ground of 472. They have quoted 472.
Where is this?
My lord, I am obliged, my lord. Next, my lord, annexure, my lord. Your lordship will kindly have a look to the next annexure. This is the, my lord, the next annexure. Now, my lord, at page 19, 20. Okay. I'm sorry, my lord. Page 20, if your lordship will come. 19, my lord.
No, page 20 is the relevant.
Relevant, your lordship. 2. Now, it says, my lord, evidence. No, my lord, I have never worked, my lord, in this particular division till date. Whatever I have done, the rural works division, my lord, I have done it in Chhapra, Sonpur and Marhauda. In this Danapur division, and I had completed all my works, my lord. They have not even, my lord, they are casting aspersion and they have not even, my lord, specified as to which of my work is pending and was unsatisfactory. Such a vague thing, my lord, and just to favor of their own candidates, my lord, they do this thing, my lord. Just in order to favor their own candidates, my lord,
It is always there.
they come out with these type of a vague, my lord, orders, my lord. When they are casting aspersion, I have not done my.
Reasons are there.
कुछ नहीं.
Annexure,
नहीं. Annexure 1, my lord.
Annexure 1.
There is absolutely no reason is 472, my lord. I violated.
Time for filing counter.
Why is counterfeit and all? We'll set aside giving you liberty.
Also, the region.
He should be heard now before passing such order. Then it is adverse order.
Also, the reason is that he has not completed the work properly, Lord.
Correct. It should be reflected in the order.
Which work?
And which work?
Which work? Absolutely, my lord. I am obliged to this.
Stated in the instant petition, petitioner has prayed for the following relief. The petitioner technical bid has been rejected with reference to 4.72 of
Agreement, my lord. I'm sorry, my lord. The notice inviting tender.
Instruction to bidders.
Notice inviting tender. It is technically called
NIT.
NIT.
So perusal of Annexure 1. Specific material information has not been relied on. So in other words, it is an unreasoned order. So Apex Court time and again held that unreasoned order shall not be passed by the authorities. In the light of these facts and circumstances, petitioner has made out a prima facie case so as to interfere with Annexure 1. Accordingly, it is set aside insofar as petitioner Lalan Kumar is concerned, reserving liberty to the concerned authority to proceed in accordance with law, if it is warranted.
Until my application is not considered, my lord, the work order may not be given to other, my lord. Because I will be feeling in my, your lordship, order will become futile.
If they have already considered,
तो ये हुजूर तो इन्हीं को बोला जाए काउंटर फाइल करने के लिए, तब उसके बाद होगा. They will come out with a plea कि I have given already the work order to
the
somebody.
event of non-processing of financial bid, the petitioner's application for technical bid shall be revisited and a decision shall be taken at the earliest.
Until such decision is taken, my lord, they should.
No.
My lordship, then.
Sir, we should not.
Lord, they are there, my lord, only to just futile and frustrate our, my lord, the legal claims, my lord. Just to favor the candidates, my lord, by.
If you don't succeed in the matter, you can file a suit for damages.
My lord, I will not be getting anything out of it, my lord.
Sir, that is the only. You can't stall the public projects, sir. Court cannot stall the public project.
The public project has to be done in accordance with law, my lord.
Correct. Shall we pass order? All right. Shall we pass order in the light of Apex Court decision? Recently, Supreme Court has held that public project shall not be.
I would certainly not invite in the interest of my client, my lord.
Sir, we should balance the public interest also.
खाली इतना ही decision लेना तक कम से कम abstain करना चाहिए.
Sir, sorry. Yes.
आज बोल देंगे तो वो फ्रस्ट्रेट करने के लिए दे देंगे दूसरे को.
CL number 25, Ram Naresh Rai versus the Union of India for the petitioner.
It is advisable भी लिख दिया जाता हुजूर दादा. It is advisable that they should restrain from giving it to any person till my decision is taken on my technical bid, my lord.
For them, now
Yes.
they have already set aside their decision.
Acha, I will be obliged, my lord.
Serial number 25 for the petitioners Richard and Bhushan Verma.
And appears list this matter after 2 weeks.
My lord, after 4 weeks, my counter of affidavit.
All right, 4 weeks.
Counter affidavit.
Serial number 26 versus Everest Human Resource Consultants versus the State of Bihar for the petitioners P.
Lordship. Earlier, Lordship had granted time for filing counter affidavit, Your Lordship. Lordship, they have served me the counter affidavit, but they have said nothing on the issue, Your Lordship, why they have rejected my technical bid on the basis that EMD has not been deposited. When the EMD was exempted, Your Lordship had on previous hearing, Your Lordship, on that day, Your Lordship had pleased to observe that that is a good ground.
My lord, may I? My lord, I have served the counter affidavit. However, my lord, I have not been able to file it in the registry.
All right, give copy. Question is whether he is liable to deposit EMD or not.
My lord, the RFP required that he was to submit a certificate of registration along with the tender document.
Where is the condition? In the
that is there, Your Lordship, and I had submitted.
You are asking him.
Sorry.
Where is such condition? He is required to furnish a certificate.
So far as this issue is concerned, in this counter affidavit, I have not stated. This point is not
correct, sir. From the document he has produced, no, from that you have to point out. Instruction to the
my lord. Page number 28.
Bidder, no?
Page number 28 is my lord.
28.
4.5.3 earnest money deposit.
4.5.3.
Yes, ma'am.
Where is the certificate? Production of certificate.
My lord, clause number E. The firm who are registered with the
Copy of the registration provided must be provided along with the technical bid. You have produced.
Yes, I
my lord, the exemption certificate. Yes, my lord, that was
not exemption. For the purpose of claiming exemption, he is required to produce the registration certificate.
My lord.
He has produced, he says.
My lord, he says that he has produced. But my lord,
but you are disputing.
My lord, what I am submitting that in the whole writ petition, he has nowhere stated that yes, I had produced. My lord, may I clarify before proceeding further that when I received the statement of facts for preparing the counter affidavit, this fact was not clearly stated.
How are you going to acknowledge, give acknowledgement that bidder has produced these many documents? Are you going to give acknowledgement?
My lord, it was to be
through online.
Yes, my lord. It was to be enclosed with the tender documents which he filed online.
No, this tender application is submitted through online.
Yes, my lord.
Yes, so what is the material to show that you have produced? He is disputing.
I don't know whether how to establish it.
Sir, when you are along with the application, what are the enclosures you have filed?
Yes,
you show us from one of the document is registration. Shall we dismiss?
Your Lordship, Your Lordship, may kindly see my statement in para 8, Your Lordship.
The statement cannot be taken into consideration. One document to establish that you have fulfilled clause E 4.5.3.
They are not giving any receiving, Your Lordship. But whatever is...
Sir, correct, sir. Through online also, if you make an application, you must indicate these are the enclosures.
Lordship, whatever we upload, Your Lordship, that is uploaded on their website, Your Lordship.
Why you did not upload this registration certificate?
That is uploaded, Your Lordship.
Then what is the material to show that you have uploaded?
Your Lordship, in that condition, we have said, Your Lordship, in para 8, Your Lordship, that
statement is not sufficient. We want material.
No bidder can be say anything, Your Lordship. No bidder can establish this fact, Your Lordship, that this document has been submitted or not.
Where is the application form?
Application form?
Type form through online.
Your Lordship.
You are not downloaded.
Your Lordship, it is because, Your Lordship, it is not open to download, Your Lordship.
Huh?
It is not open to download.
Then for your record purpose, how do you maintain?
वो हमारे पास है, हुजूर.
Give that.
May I be permitted to bring it on record, Your Lordship?
Yes, take one. Short question for consideration is whether petitioner has enclosed registration certificate of MSME so as to claim exemption to submit EMD in terms of clause of 4.5.3 of eligibility criteria. The petitioner is hereby directed to produce necessary material to establish that he did produce a copy of the registration of MSME certificate, which is disputed by the non-counsel for the respondents. This is matter of 3 weeks.
Earlier हम तो उसको तुरंत फाइल कर देंगे और earlier दे दिए
2 weeks.
My lord, the counter affidavit has been.
Before that, counter affidavit filed on behalf of respondent. Respondent number?
Respondent number 3 and 4.
3 and 4.
Serial number 27, Ram Sagar Sharma versus the State of Bihar for the Municipal Street Maharashtra.
Lordship's rejection of a technical bid on the ground that I had not submitted along with the tender document online the registration certificate. But I have made a categorical statement that it was submitted. The bid acknowledgement certificate which is issued pursuant to submission of the bid document, it also acknowledges that yes, I have uploaded the registration certificate. My lord, you'll find that page 20 is the improved decision.
Page?
Page 20 of the writ petition is the improved decision. It says that I have not submitted online the registration certificate. This is Jacho Pran.
There is a clause number 1, 2, 3.
Yes,
clause. 11.
It's clause 11. Yes, it's clause 11 on the next page. Jacho Pran. After.
Who can read this?
No, there's a type copy there afterwards.
Huh?
The type copy is next.
Where?
The next page is the type. Page 20 follows with the type copy of page 20.
What is this general instruction?
Yes, this is generated once we upload the bids.
Which is the relevant column?
The last page shows that list of documents which have been uploaded along with the tender. The first says that a registration certificate has been uploaded also.
They are disputing that GST registration certificate.
No, the general registration that as a contractor, being registered as a contractor.
No, contract registration certificate is in respect of which column? Sir, which is the column which is required?
I'm sorry for the inconvenience. I had only 2 copies. If one, my lord, just for assistance, I'll just.
You have financial.
No, lordships, actually.
Not getting Xerox copy.
Lordships, I'm very sorry, lordships.
This is division bench.
Lordship, the internal page 3 of the.
License and registration.
The last page, serial number 15.
Number?
15, the last entry. Registration certificate with building construction department, civil and lottery, it has been uploaded.
Your Lordship, instructions is under process, Your Lordship. Kindly, under process, Your Lordship.
Instruction?
Yes, Your Lordship. Counter के लिए Your Lordship, may kindly grant 4 weeks time, Your Lordship.
All right, we'll grant you, but we'll stall further proceedings.
But it will not serve the copy of this.
Copy of what?
I have no.
He has not served to us. How do you expect?
Your Lordship, may kindly see page number 20, Your Lordship, Janch Uprant. Janch Uprant, number 1, number 2, and number 3 is petitioner. Ram
All right, take this copy. Learn counsel for the respondents concerned respondent is hereby directed to file counter affidavit positively before the next date of hearing. In the meanwhile, further proceedings, if any, shall be stalled till the next date of hearing.
I'm very sorry I could not give the 2 copies. There was some.
Sir, sorry is the only word, sir. I'm hearing time to time. Sorry.
4 weeks back.
Not 4 weeks, sir. 3 weeks, sir.
Serial number 28, Sanjay Kumar versus the Chief Engineer for the Distance Vimanathan.
Lordship, happy. So the petitioner, Lordship, has challenged the order as contained in Annexure 1, page number 19, my Lord, by which petitioner was debarred from taking part in next tender. Name of the petitioner appears at again serial number 153, 154, 155, and 181, Your Lordship.
Wholesale debar.
My Lord.
Wholesale debar.
My Lord. Along with many other persons, Your Lordship, the petitioner was also debarred. And
so joint venture.
My Lord, it is a very mechanical order, Your Lordship. May kindly see.
What are the reasons, sir?
Nothing. Only one reason that the petitioner could not complete the work within time. But the matter is, my Lord, the time was
not sufficient.
The time was extended by the chief engineer itself, and again the work was completed. Inspection was done. Work was found to be satisfactory, and find Annexure 11, Your Lordship. Even the executive.
What is the date of such opinion expressed by the chief engineer?
Opinion regarding
that you have completed satisfactory work and.
My Lord, not of the chief engineer, but of the executive.
That's how you submitted chief engineer.
My Lord, of the chief executive engineer, Lord. I'm sorry if I have submitted that.
Chief executive engineer.
That is page Annexure 11.
Is there any post of chief executive engineer?
My Lord, executive engineer, Your Lordship.
Executive engineer.
My Lord, Karyapalak Abhyanta, my Lord. Karyapalak Abhyanta. Date is, my Lord, 25/11/2017.
17.
Your Lordship.
What is the date of the impugned decision?
2016, my Lord.
2016. You are challenging in 2023.
My Lord, we have completed the work after extension.
Correct. You can't challenge.
My Lord,
of these many years.
No, my Lord. The thing is that we are not challenging that said order. We complied with the order.
No, sir. You are challenging blacklisting.
Because on the very ground, my Lord, कि हमको डिवाइड जिसमें किया गया था.
On the ground of delay and lapses, will sir.
Kindly see, my Lord, Annexure, last Annexure, Your Lordship, that is Annexure 12, my Lord. Similarly situated person, my Lord. I was arguing in that case also, Your Lordship.
So you are a fence sitter.
No, my Lord. Then, Lordship.
Sorry, we will not. Just take on.
Your Lordship, may kindly see one thing, Your Lordship. I have filed representation before Your Lordship, engineer and all, my Lord. I moved from pillar to post.
On submitting representation.
My lord, they did not pay any heed upon the precondition file upon. My lord, the whole carrier, my lord, will
Sir,
be.
we will not interfere in respect of 2/6/2016 letter number 6/777.
My lord, just one thing. I am reading out the annexer 1, your lordship. किस ground पे हुजूर उसको वो करते हैं?
Lost its effect. I'm just seeking a disclosure that it could
My lord, but for one work, your lordship, that could not be completed within time, the petitioner cannot be debarred out, matlab, in for future, your lordship. In order to take part in any next tender, your lordship, he has been debarred from taking.
Debarred for how many years?
Debarred from for the future. It's not for limited period, your lordship. पढ़ देते हैं हुजूर एक बार हम.
All right, we will make an observation. From here afterwards, he may be permitted to participate in the process.
Your lordship, obliged, my lord.
You read the last line of a letter dated 2/6/16.
Your lordship, my lord.
विभाग द्वारा डिफॉल्टर घोषित करते हुए
My lord.
परीक्षा में भाग लेने से वंचित किया जाता है.
इन प्रावधानों के
How come it has for all time to come?
My lord, जब your lordship, unless and until they do not recall the said order, my lord, we are restricted. I am restricted from taking part in any next tender, my lord. I am not participating even, my lord.
Sir, from 2016 to 2023, have you tried to participate?
Yes, my lord, we have. I have. My lord, in the internet, my lord, even the state can file a state.
In your pleadings.
My lord,
I have participated and it has not been considered.
My lord, I may.
Where have you pleaded?
I may submit one thing, your lordship.
Please answer to the court question. Where have you pleaded that I have been prevented even to this day in participation of tender?
My lord, paragraph 14, my lord.
Paragraph 14.
My lord.
No, where is the debarred list?
My lord, debarred list is at annexure 1, my lord. And paragraph 14 may I have pleaded, my lord, that despite the aforesaid facts,
petitioner has.
Your lordship may kindly, my lord, one thing.
Please allow me to give dictation. We have heard you sufficiently. Petitioner has prayed for the following.
Person has been allowed, your lord.
Take your seat, sir. We have heard you sufficiently. In the instant petition, petitioner has prayed for the following relief. Having regard to the relief sought in the present petition, the petitioner had a cause of action in the year 2016, whereas the present writ petition is filed in the year 2023. Further, it is to be noticed that petitioner has been debarred for the next tender process, and it is not for an indefinite period. So, in the light of these facts and circumstances, the present petition stands dismissed on the is liable to be dismissed on the ground of delay and laches. At this juncture, it is necessary to take note of apex court decision in the case of Jammu and Kashmir versus so and so. Para 20 reads as under. One of the principles laid down by the apex court in the cited decision before entertaining any writ petition, court has to take note of delay and laches issue also. Accordingly, writ petitions stand dismissed.
My lord, must one submission, my lord. मैं kindly एक observation दे दिया जाए हुजूर कि next tender में participate करने के लिए my lord कम से तो my lord whole career बर्बाद हो जाएगा.
Sorry, sir.
My lord, similarly situated person का my lord, I was arguing counsel, my lord, it was allowed by the annexure 12, your lordship. In the counter affidavit, they have removed the list of.
After disposal of the matter, counsel for the petitioner is abusing the process of the court.
Sorry, Your Lordship.
Hence, writ petition stand dismissed with the cost of rupees 25,000. Cost shall be remitted in the High Court Legal Service Authority within a period of 8 weeks from today.
My lord, I'm sorry, I'm deeply sorry.
And we are sorry, sir.
Sorry, Your Lordship.
Sorry.
My lord,
Serial number 29, Messrs. Goodyear Security Services versus the State of Bihar for the Petitioner Shri Ashok Kumar Singh.
Also, the Patna Municipal Corporation routed a tender for supply of manpower of various classes, Your Lordship. I was one of the tenderer. Your Lordship, out of 12 persons, 12 bidders, Your Lordship, four bidders were shortlisted, including me, Your Lordship. And thereafter, Your Lordship, out of these 4, 3 were selected and I was, Your Lordship, left out, even though I was the 3rd lowest bidder, Your Lordship. And the 4th lowest bidder has been selected, it will be apparent from Annex 1, Your Lordship, the impugned order, at page 14. Also, Virtuous in India Private Limited, Messrs. Modian Cars and M4 Solution. Lordship, M4.
What is the reason?
Lordship, they have not assigned any reason, Lordship, but the papers which have been brought here, Lordship, it clearly shows that out of these 4 bidders, Lordship, I am the 3rd lowest. And Lordship, the M4 Solution is 4th lowest, the last one.
Have you included those bidders?
Lordship, I'm sorry, I had not. Lordship,
You
sir,
are also
I will. Lordship, I will seek permission, Lordship, to add only, not all 4, Lordship.
Whatever it may be, have you included such of those persons whose bid has been?
I ought to have it, Lordship. I ought to have, Lordship. By tomorrow, I will add, Lordship, M4 Solution Private Limited.
Petitioners have not arrayed necessary and proper parties. In this regard, petitioners were permitted to file interlocutory application in impleading necessary and proper parties. This matter next week.
Serial number 30 is adjourned for 2 weeks. Serial number 31, Messrs. Star Construction versus the State of Bihar for the Petitioner Shri Lokesh Kumar.
Kindly pray for 1 week time.
After 2 weeks, the request of the council for
Serial number 32, Namas Civil Construction Senior Contractor versus the State of Bihar for the Petitioner Shri Ashish Devi.
Petitioner is a company, and on a wrong notion that some work of constructor work by one of the directors of the company was pending, the tender of this company has been rejected. And Lord, I have also arrayed as a private respondent, as a respondent number 9. It is because to favor them, who is a disqualified candidate, my Lord, I have been rejected and the private respondent number 9 has been favored.
What is the reason for rejection?
Yes, my Lord, they say because one of the director of this company, my Lord, there was some pending work and ATR against him, and therefore in terms of clause 4.7, my Lord, the tender is rejected. My Lord, may just have a look at that order. The final order is at page.
Not 1 ATR, 3 ATR.
Yes, 3 ATR against the director, and that is also, my Lord, now there is a subsequent document by which, my Lord,
No, if there are any ATR against a director, that should be ignored.
Not at least to the extent of company. He has taken this work individually, and under the PWD code, my Lord, each of the companies and the direct or any individual have a separate registration. And my Lord, even otherwise, assuming, my Lord, for an argument that the directors can be considered, my Lord, in there, my Lord, we have categorically stated that pending IR was also taken away, though subsequent to the date of submission of the bid. But for private bidder, my Lord, respondent number 9, they have accepted a subsequent document and held it to be qualified, while, my Lord, my subsequent document they have failed to consider.
For the identical work, your earlier bid was
accepted.
Rejected.
No.
Yes, rejected.
My Lord is seeing page 51. For the identical work, my Lord, that earlier rejection, they had recalled it, my Lord. The earlier rejection was because they said that some document I had not annexed. So I made...
Earlier also it was rejected.
Then they recalled it. And they said now they rejected it on the ground that I don't have an ATR. There was an ATR against me in terms of clause 4.7. And my Lord, clause 4.7 has been interpreted by this Honorable Court saying that, my Lord, it is not a ipso facto clause which will automatically apply, my Lord. That is a case where, my Lord, there is a black mark against us, provided there is a notice given to me, a chance given to me to explain the... Yes, my Lord, I have annexed it at page, annexure 8, page 59. is the SPD document. The relevant is at page 64. So, my lord, there are two issues. This is, as far as I am concerned, my lord, they say 4.7. It only says record of poor performance such as abandoning the work. So it could not be an ex facto opinion, my lord.
But you should have challenged this clause. That this is impracticable to implement.
This can be implemented provided there is a natural justice compliance, my lord. The courts and my lords have held that, my lord, such clauses, the natural justice is inbuilt. But my lord, any way of the matter, my lord, my lord will just see one paragraph of the impugn order. What the basic allegation is that we stated that this ATR was removed now. Please have a look at page 51.
Then what remains?
So what they say, my ATR has been removed subsequently, and that is why we can't look into it. Whereas, my lord,
what is the reason for removal of ATR?
Work was completed, my lord.
Work was completed.
Yes.
But otherwise, during that relevant period, you are facing ATR.
My lord, that is what I am saying, my lord. I am understanding.
That is sufficient.
My lord, even assuming if for a sake, my lord, we assume that even at that period of time it was sufficient, then my lord, the same parameters ought to be have adopted for respondent number 9. Now for respondent number 9, what they do, my lord, after the date of submission of the bid, my lord, we had made an allegation that they are disqualified because they do not have the sufficient experience certificate. Now they consider an experience certificate after the submission of the bid and hold it to be qualified. And my
to notice to 9th respondent. This is a judicial period within a period of 2 weeks. In the meantime, concerned official respondent is hereby directed to file counter statement. List after 4 weeks.
There can be a shorter date if possible.
No.
Private. Oblige.
Serial number 33, discuss.
May I just pray any action be subject to the outcome of the writ application?
Serial number 33, discuss security services and their private versus the state of Bihar for the state of Rashid.
May it please. Prayer in this writ application is for direction of the respondents. Take on record the entire documents of tender evaluation valors pertaining to tender number E83, which pertain to supply of manpower services valors, including carpenter, plumber, data entry operator, etc. So the facts of the cases are
Why are you asking for direction to bring the record?
Valors, because more than 2 years has elapsed. No decision has been taken on the tender. The bid validity period was only 120 days. No action was taken. I kept on giving representations that the tender may be finalized. It never happened. Now we have come to know that after the expiry of the bid validity period, the tender is going to be awarded, my lords. So, my lords, our submission is that they should bring on record the tender evaluation committee's report. Secondly, they should cancel the tender because once the bid validity period has expired, they cannot accept any of the bids, because
file your counter.
My lords, in the interim, my lord,
filing counter statement in next date of hearing, list after 3 weeks.
My lords, they should not finalize the tender, my lords. Plus, because admittedly the
bid process commenced in the year 2021.
My lords.
We are in 2023.
My lords, but I have recently come to know, my lords, that they are awarding the tender, my lords. My lords,
we have come to know just 5 minutes back.
My lords, kindly consider that even prior to this.
Sorry, Mr.
Obliged.
Infrastructure private limited versus the state of Bihar.
My lord, this writ application has been filed for a limited purpose, my lord, for direction upon the respondent number 3, that is the Managing Director of Warehousing Corporation, for considering the representation of the petitioner for extension of time, my lord. In spite of repeated representation, my lord, till
for what?
For extension of time, so that the petitioner can complete the project, my lord.
Go and approach.
I have approached
arbitration.
No, my lord, because I have completed more than 90% of the project, my lord.
This court cannot extend the contract period.
My lord, because there is provision in the contract itself under 2 provisions, clause 39 and 51, extension can be granted, one by 1 year and under the force majeure clause, my lord. My lord, in annexure 5, that is
not tinker the contract.
My lord, may I kindly appreciate, my lord, that in the middle of the corona period, the petitioner was asked to sign the agreement with an assurance that the extension will be given as per the agreement contract, my lord. My lord.
Go and apprise.
I have, by annexure 14, my lord, I have requested.
Sorry, sir, in the agreement you have a remedy of
My lord, but my lord, arbitration, my lord, will come to, the question will arise when they are not. They have given me extension under force majeure one time, another under clause 39. Which
how many times you want to repeat? Do you think that this court will not understand?
My lord, because my lord may appreciate that I have completed 90% of the project. 10 crores I have spent, my lord. 10 by putting collateral security, my house in prime location in Patna, my lord, I have taken loan, my lord. Now only 10% of the project is remaining. I am seeking extension only for 3 months, which they can give as per the terms of the agreement, my lord. My lord may only bear.
In terms of clause 60 of the agreement, the petitioner has a remedy before the competent authority. So the question for consideration is whether petitioner is entitled to extension of time to execute the work or not. The disputed issue, which cannot be adjudicated by this court under Article 226, the right of appeals court decision in the case of Shalini Sharma.
My lord, it is not a disputed question. My lord may see clause 39 of the contract agreement at page 62. It specifies that the extension can be given, my lord. It is not the case that it cannot be given.
Better withdraw and go, otherwise this will come in the...
My lord may pass order on merit.
I have passed order. We have passed order on merit.
Because under the agreement itself, it provides under 2 situations extension can be given.
Sir, you go and agitate before the jurisdictional arbitration. Arbitration clause is there.
My lord, that arbitration clause invoking that will hell lot of time will be involved, my lord. But as per the agreement,
sir, that is the reason the writ court cannot be abused in this fashion. When you have a remedy elsewhere, you can't invoke 226.
Serial number 35, Satyendra Kumar Construction Private Limited versus the State of Bihar.
This is the decision of the respondents reopening my process for blacklisting on the basis of a show cause notice which has already been quashed by this honorable court. If my lords please to see, the show cause notice is annexure 4, page 36. It's letter number 3530 dated 6/5/2022.
6/5?
Yes, 6/5/2022. That was followed by my order of blacklisting at annexure 6, page 41. This was both the show cause notice as well as the order of blacklisting was challenged before this honorable court, and while annexure 7, both the orders were quashed. Annexure 7, page 44.
What happened now?
Thereafter, Lords, on the basis of the the order, Lords, of the relevant is page 59. Last line, if my lords is pleased to see the order of this honorable court. As such, on this short ground alone, the impugned show cause notice dated 6/5/2022 as contained in letter number so and so, and consequential office order number 83 dated so and so passed by the respondent of name so and so, set aside, there was a liberty grant. Now, on the basis of the same cost show cause notice, they have again opened the proceedings.
Where is that?
Yes, annexure.
When they have been given liberty,
so they should have issued a fresh show cause notice. Now they are giving effect to the same show cause notice. Annexure 11, page 62, if my lords is pleased to see. Now they say that, Nideshanusar, they say that as per the liberty granted, as per the corporation letter number 3530 dated 6/5/2022, you are asked to submit your reply by 17/1/2023. This is the same show cause which has been quashed. Again, they are doing the same thing. They are giving me a last chance. If the show cause notice was caused, the matter has been remanded pre-show cause stage.
Your Lordship, that is fact, but Your Lordship, the given opportunity, because last occasion it was quenched, Your Lordship, because the proper opportunity has not been given. So opportunity has been given to.
Correct. How can you rely on past communication?
Because Your Lordship and.
No, why can't you issue fresh?
Your Lordship, then Your Lordship. Otherwise, Your Lordship, because the issue is same. Because
Correct, sir.
has not been.
Why are you relying on past communication? Firstly, you have to type the show cause notice and give it to him.
However, Your Lordship, my instruction, Your Lordship, argument, hearing has already been concluded of the petitioner. Hearing of the petitioner has already been concluded. He has appeared before the authority, Your Lordship.
I have not appeared before the authority. I have challenged this. I have only made a communication that I have challenged on this decision.
Take fresh exercise. Yes, Taylor. In the instant petition, petitioner has prayed for the following relief. Insofar as the issuance of show cause notice dated 6/5/2022, read with 9/6/2022, petitioner has approached this court filing CWCC 1564 and it was set aside on 18/11/2022. In this backdrop, the concerned respondent should have resorted to issuance of a fresh show cause notice instead of relying on earlier quashed show cause notice dated 6/6/2022, 6/5/2022 and 9/6/2022. So, the impugned communication dated 10/1/2023 perusal of the material information stated in Annexure 11 dated 10/1/2023. Concerned authority has proceeded to rely on past communication and it is not maintainable. Accordingly, Annexure 11 10/1/2023 stands set aside, reserving liberty to the concerned authority to proceed afresh by giving a detailed show cause notice and seeking a petitioner's explanation and proceed to pass speaking order and communicate the same. The above exercise shall be completed within a period of 3 months from the date of receipt of this order. Writ petition allowed.
Thus, Annexure 11 and Annexure 12 both are under challenge.
What is 12?
The 12 is reiteration that a next date was also fixed.
11 and 12 set aside.
Problem.
Serial number 36, NIT Developers Private Limited versus the State of Bihar for the business to
This is a case where a notice to show cause contemplating the action of rescission of the agreement is under challenge, because I am conscious of my fact of my limitation while arguing and challenging a notice to show cause. Admittedly, in this case, the agreement stands completed, the works stand completed and agreements stand concluded. Then, Milords, I have completed a work more than, and Milords, their deviation amount is 22 crores and all. After the work was completed, when the proposal for making the payment was given, now then the executive engineer say that why your agreement be not rescinded. When the agreement has already been concluded, the work stands completed, there is no question.
What is the date of completion of?
Yes, I have annexed the certificate, it is 6/7/2022, annexed 6 July 2022. As per quality specification and everything.
Right, now within 10 days they have taken action.
No, it is not after that in 2023. It is 4/2/2023, Annexure 5 page 49 is included after more than 1 year.
Now, what is the communication of chief engineer dated 16?
He says that the extra work which I have done, he recommends that payment should be given to this man. Now, when this reaches the headquarter, then instruction, if my lord is pleased to see, it says that 88.81% वृद्धि हुई है, that payment should be given to this petitioner because he has already completed the work. And thereafter, after this is of 15/7/20.
Okay, show cause. Go and file your reply.
The next thing is, if my lord, no reply can be, just want to blacklist me and immediately if it is rescinded, automatically I will be blacklisted. No reply can be given to this. For the reason, if my lord is pleased to see, just the word is.
Sir, we will make it clear that go and file your reply to the show cause notice. till then, let them not take a precipitative action. That's
Yes, yes, Lordship. But only one thing, my lords, I'm just for my satisfaction. Lords, the language in the show cause, my lords, I've been constantly holding that on what grounds, but I opened my argument by explaining my limitation. No man of ordinary prudence can answer this. कभी मौखिक रूप से आपको बोला गया था. Because there is no specific environment and this is contrary to.
It's a good ground for you.
Because this is already
good ground for you.
Lords, it is against, my lords, it is against the terms of the SBD, my lords. My lords,
Talking about letters.
no letter, my lords.
Letters and orally or verbal.
It is no letter has been mentioned. That is my case, my lord.
पत्र के माध्यम से.
So there is no patra, which patra there is. It is not even annexed with that show cause notice. This is my predicament. The मौखिक रूप से बोला गया, and the same. If my lord is pleased to see, this is the same executive engineer who has issued the completion certificate.
Sorry, Mr. Gwin. Yes, take down in the instant petition. Petitioner has following relief. Prima facie, the petitioner has assailed the show cause notice dated 4/2/2023 and sought consequential benefits. Mr. Writ Court cannot interfere with the show cause notice unless and until it is contrary to any statutory rule or by an incompetent authority. Both the ingredients are not forthcoming in the present petition. Accordingly, writ petition stand dismissed, reserving liberty to submit his explanation to the show cause notice dated 4/2/2023 at the earliest. Because of the concerned authority hereby directed to take note of petitioner's explanation and proceed to pass final order. In the meanwhile, the concerned respondent shall not take any precipitative action against the petitioner.
Yes, because only one liberty may be given. I may be permitted to ask for the documents because this may not.
That is always there. Go and ask the.
If it is indicated, then because only one line to that effect that I will.
And counsel for the petitioner submitted that show cause notice is a breadth of material information. In the event petitioner seeks any material information, the concerned authority shall examine as to whether the petitioner is entitled to such material information or not. If he is entitled, in such circumstances, the same shall be provided.
See, about 37 Amit Kumar Singh versus the State of Bihar Petitioner Sri Ram Krishna.
Wait, please, my lord. This is a matter where I've been blacklisted for 10 years, my lord. I'm a government contractor. And I was.
What is the allegation against you?
My lord, that there was interpolation in the experience certificate, my lord. But at least they should have.
Serious allegation.
My lord, but they could have issued me a show cause notice. I may be a murderer, my lord, but they need to at least hear me out before completely blacklisting me for a period of 10 years, my lord. That is my only prayer over here. Because
where is the order?
Yes, my lord. My lord, may see page 30, my lord.
Page?
Page 30 of the paper book, my lord. Order dated 17/12/2022. So it says that because the interpolations and because there was no Samanta in the experience certificate, they clearly blacklisted me for 10 years, my lord. The last line. I filed a representation subsequently, my lord.
Who has declared that certificate is
My lord, they, after having declared me as successful in the tender, my lord, they got the experience certificate verified.
Why the petitioner was not given opportunity? Behind the back of the petitioner, you have taken a decision.
Lordship, I have to, that aspect of Lordship, I have to file affidavit because
it is not there.
Because,
No, it must reflect, no.
Your Lordship, but fake certificate has been given because
all right, sir,
that tender process, Your Lordship, has been kept.
It is he is entitled for notice and other things. Behind the back of the petitioner, can you take a decision that he has produced a false certificate, fake certificate?
Your Lordship.
Shall we set aside or what?
Your Lordship, I have to file because I am not aware because this.
Take down. Then counsel for the concerned respondent is hereby directed to file counter affidavit positively before the next date of hearing. Because the concerned respondent counter affidavit has to say as to whether the petitioner has been provided an opportunity of hearing or notice before passing Annexure P4 dated 17/12/2022 or not. Just after 3 weeks.
Lord, my only one problem is that I'm not able to participate in the tenders, my lord, because of...
Yes, you have to wait.
As my lord. Obliged, my lord.
Serial number 38, Mr. Sanjay Printing Works versus the State of Bihar for the Christmas period start.
In this case, my lord, the annexure 1, the indefinite period has been blacklisted on 19/3/2020. Thereafter, my lords,
2010 order. 2010 order.
Yes, my lords.
We are in 2023.
What happened, my lords, issuance of for direction. Then I filed a writ application, my lords, by annexure 2. Thereafter, the annexure 3 is come for reducing the period of 3 years. The period of 3 years has been completed on 19/6/2021.
Then why are you challenging the 2010 order?
No, I am not challenging any order, my lord. I am only prayer, my lords. I have completed the period, may be allowed to the participate of future tender and purchase.
Prayer.
I am challenging, my lords.
Read your prayer, sir.
No, first prayer is wrong, my lord. Second prayer is right, my lord.
Then delete it.
Yes, I permitted to delete, my lords. And the annexure 4 is come, my lords.
Sir, first delete, sir.
Yes, my lords.
Delete and put your signature. You are advocate on record.
Yes, sir. ऊपर वाला फर्स्ट
काट दीजिए रेटेड कितना
ये 1014
Put your signature, date.
This is printed in Pakistan. What is that? Printed in government page? Don't have government page. But you have to take more before going for private.
What is the second prayer?
Second prayer, my lords, for issuance of a direction to the petitioner will not be debarred from participate of the future tender and purchase.
In which there is a cause of action, in which tender you have participated and they refuse to accept your tender bid.
Going to be published, my lords.
So you can't speculate and file a petition. And when if they reject, you come here.
My lord, this similar order has been passed by the
No question of similar.
bench, my lord, of this one will
On
go.
speculation, you can't file writ petition, and we can't grant relief. Better withdraw this. As and when cause of action accrues, you file it.
My lord, I will take instruction whether this tender is published or not. Maybe 1 week time may be granted, my lord. Then I file a supplementary bill. If any.
Prima facie writ petition is speculative litigation. In order to give one opportunity, release this matter after 2 weeks. It is made, further time would be granted.
May I have the order sheet to mention, my lord?
Huh?
May I have the order sheet to mention, your lordship?
What?